Aloha and good morning, everyone. It is Thursday, September 26, 2024, and the time is 9:11 a.m. Will the Committee on Planning and the Economy meeting please come to order? I would like to welcome Council Members Okimoto, Say, and Wire. I understand that several members of the committee or other members who wanted to attend are stuck in traffic, and so I'll be recognizing them when they come. Pursuant to Hawaii Revised Statute Section 92-3.7, this meeting will be conducted as a remote meeting by interactive conference technology with the following procedures in effect for the meeting. Members of the public will be allowed to provide oral testimony on all items on the agenda when each item is taken up in two ways: in person in the council chamber and remotely via teleconference or phone. Each person will be limited to a 1-minute presentation on each item. All persons who register to testify in person will be called upon first. When your name is called, please come up to the testifier podium and begin by stating your name for the record. Persons who did not register will be given an opportunity to offer testimony after the registered testifiers. Once in-person testimony has concluded, I will take testimony from the remote testifiers when I call your name or the last 3 digits of your phone number. Please follow the prompts to unmute and begin by stating your name for the record. HRS Section 92-3.7 requires all votes at a remote meeting to be conducted by a roll call unless unanimous. Therefore, if any objections are noted, I will call for a roll call vote. Written testimonies, including the testifier's address, email address, and phone number, will be available to the public as described in the posted agenda. As a courtesy, please turn off or silence all cell phones for the duration of this meeting. Thank you. Members, if there are no objections, I will take the agenda items out of order, given the fact that Councilmember Tupola has done a lot of work on both agenda item 1 and item number 2, and so I'm going to be taking up agenda item number 3 at this point. For those of you who may be, for anyone else who may be coming later who was unable to testify on this item, I will allow an opportunity to testify after the end of the other 2 items. Welcome, Vice Chair Cordero. So, moving to agenda item number 3, informational briefing. Status of the City and County of Honolulu's enforcement for violations in the State Agricultural Zoning District, 94-1211 Kunia Road, Waipahu, Hawaii 96797, tax map key 9400420. Before we take public testimony, I would like to call on the administration. For the administration, we have Mike Formby, Managing Director, as well as the Director of the Planning and Permitting Department, Don Takeuchi Apuna. Thank you for being here.
Good morning, Committee Chair Kia'aina, Vice Chair Cordero, and Council members. Mike Formby, Managing Director. And as you noted, Director Don Takeuchi Apuna is also here. And so I appreciate the opportunity to speak in the context of an informational briefing about what the city is doing to enforce on certain activity at the Hawaii Country Club, specifically the Mauka Warrior Luau. And I want to speak primarily to the administration's policy position, the steps that we've taken, and then if you have specific questions about rules, regulations, ordinances, and statutes that DPP can use, Don Takeuchi can speak to those. So I have before me the list of notices of violations that have been issued, and I'll just give you dates. They begin September the 1st of 2023, December 7th, 2023, December 18th, 2023, April 8th, 2024, April 16th, 2024, May 8th, 2024, August 23, 2024, June 4th, 2024, June 12th, 2024, June 28th, 2024, August 2nd, 2024, August 9th, 2024. And then after that, we have 2 letters, which are orders to cease and desist luau operations, dated August 30th, 2024. And they're to both Malka Warriors, as well as Mr. Guy Fong on behalf of Hawaii Country Club. And these letters basically ask the operation to cease and desist. The administration has had 1 meeting, the mayor and I specifically. I shouldn't say the administration because I'm not sure if Dawn's had more meetings, but the mayor and I had 1 meeting with Malka Warrior Luau and their attorney. And the purpose of that meeting was to ask them where they were in their efforts to relocate, and also to advise them as to the administration's position on enforcement. And we understand that they are trying to relocate to land that would allow that activity. And we advise them that we have to continue to enforce, which we have since that meeting, and we're presently moving towards judicial enforcement. So there's been a lot of emails, and there's been a lot of talk, principally from one source, and that one source has sought to dictate to the administration how we should enforce in this case. And that source has spoken in a way that I personally want to say I don't appreciate, and I refuse to answer the questions that they put to the neighborhood board and to the administration, because they do not get to dictate how we enforce. We get to decide. We have many options on how to enforce, and those options are constrained by the context of the operation. In this case, the Hawaii Country Club is a permitted activity to operate a golf course on ag lands. They're permitted. They have a contract with the luau to operate on their property. So that is a third-party contract. That is not a direct permitted activity doing something unpermitted on their property. It is a contract between the country club and Malka Warrior Luau. And this individual that is speaking to the neighborhood board and writing the Department of Health and writing legislators and writing council members and making all kinds of disparaging remarks is demanding that the city take direct action that would breach the contract between the country club and the luau. And we've chosen not to do that because the luau has existing operations. They have jobs. They have contracts with bus companies. They have contracts through agents that are selling tickets. They have subscribers for future tickets. And the city is not going to go onto another entity's property and unplug their electricity and shut down the luau operation. That would set the city up for all kinds of litigation, for potential breach of contract claims, interference of contract claims, whether we agree that those contract claims are legal or not. We do not want the taxpayers of the city and county of Honolulu to be personally responsible for removing the luau operation. Why should that be on the taxpayer's account? The city and county did not contract for them to operate there. The country club did. So if they want to remove those luau operations, they should have to do that. And if that becomes a contractual issue between the luau operator and the country club, let those two play that out in the court system. But we do not believe that the city needs to do that because we're now going into the judicial enforcement. So that's the status of the case. And I'll tell you, I'm very disappointed in this one individual who has publicly posted YouTube videos of Director Dawn Takeuchi Apuna disparaging her, calling her incompetent, stupid, dumb, colluding, scheming, conniving, has accused the administration of working with the Ethics Commission to to allow this unpermitted activity. And we don't have to take that kind of personal attack as public servants. And I'm here to tell you, we stand behind the decision that we've made on these notice of violations. I'm happy to get the council's members copies of every one of these, as well as the cease and desist letters. And as we go into judicial enforcement, the operators of the luau will have the opportunity to tell the court what they believe their rights are to be there and what representations were made to them by the operator of the country club, who, by the way, that agreement is signed by Mr. Tom Berg in 2023. Let them play that out in a court of law rather than the city and county being involved in litigation at great expense to the taxpayers. So we've made policy decisions that we believe are reasonable and fair. We've not colluded with any council member, although that has been put in email as well. We've been accused, this administration, of colluding with a council member to sneak in the permitting of this activity through Bill 64. Hasn't happened. Never been discussed between me and Committee Chair Kia Aina or any council member. We've simply asked to have the opportunity to explain the position that the city is taking. And that is a position that we believe is reasonable under the circumstances, allows this operator who has current contracts, people working, doing good work, to work with the country club, which contracted with them to do that work on their property. Let them work that out while the city seeks to enforce. So I don't appreciate what's going on at the neighborhood board and in the email out there, and I apologize to the council to the extent that you've been drug into this as well. I don't think it's fair to the mayor, who's been called a swamp creature, by the way, and had his face posted on YouTube. I don't care if they post my face on YouTube, but to do that to Director Don Takeuchi Apuna, who has taken on the reformation of DPP with the competent and expert staff of DPP, probably the toughest thing that DPP has ever done in the last 8 years to try to reform that agency so that we can more efficiently and effectively issue permits. To call her incompetent, dumb, stupid, conniving, unacceptable. So we're here to answer any questions about either the enforcement or the ordinances that allow us to enforce, but I want to let you know we're not answering questions from certain sources that have made unprofessional claims against the administration. So thank you very much.
Thank you, Managing Director Formby. I concur that there's no room for that type of disparaging remarks against anyone in the administration or any member of the City Council. And I can confirm for anyone that is listening that there is no effort underway to sneak in an amendment to Bill 64 to make the operations on this property legal. So before we move to questions and discussion, members, I would like to take public testimony. And as I mentioned earlier, because I took this agenda item out of order, I will be allowing for testifiers who may have thought that this was going to be later in the agenda to be able to testify after Bill 64. So the first testifier is Mr. Tom Berg. Is Mr. Tom Berg online?
Yes, Chair.
Mr. Berg, please proceed.
Yeah, I'm really offended. Can you hear me? Can you hear me, Chair?
Yes, and
Aloha.
yes.
Yeah, I'm very offended what was just said because those are untruthful statements that were made by Mr. Formby. Let me explain the truth, what's happened here. HRS 205-13 mandates that the city and county remove the appurtenances and structures that were built illegally without permits that expand the floor area. DPP enforced the law on Hawaii Prince Golf Club in 2019 and mandated they remove what's called a wedding trellis. So we have unequal enforcement going on. So all I've been trying to do is get what's called equal enforcement. So basically what the chair, Formby, has said is that if you guys go in executive session and someone's suing the city because someone got killed by a tour bus, we taxpayers are going to pay because the luau's not supposed to be there. You're not enforcing the law. If there's a fire that takes place because they don't have a permit for an open fire, we're going to get sued. More importantly, Department of Health ordered them to stop using a retrofitted shipping container that violates HRS 205-8. Dawn Apuna has refused to enforce the laws she's enforced on other golf courses that DPP rather did in 2019. So to be clear, if you read my 12-page testimony, you will find out that DPP tore up the original cease and desist order in December of 2023 because they're claiming, you just heard it.
Mr. Byrd, could you please wrap up your testimony?
Yeah. You know, somebody on the council asked a question here. Somebody have in good faith, because my name's been disparaged. I quit. I was ordered. I was forced to sign a contract that I didn't sign. I refused. So they put my name on a contract by computer. I objected. I quit my job there because I saw tour buses almost killing people. I saw the risk of fire. And so for the managing director and DPP to tell you they could enforce the laws, they could work with the Department of Health. The Department of Health has an illegal septic there, and the luau is using it 5 nights a week in defiance of the Department of Health. This luau that he says is acting in good faith got caught for serving alcohol for 7 months without a liquor license, and they're still doing it today. So we have liquor laws being violated. We have Department of Health laws being violated. And as we speak, other golf courses who were told to abide by 205-8, that you can't expand the floor area, Dawn Apuna is allowing them to violate those laws. Please, everyone, read my 12 pages, because all you council members, when you go into executive session and somebody's suing the city because an attorney says, my client got killed by a tour bus that's not supposed to be there, do you know what they're going to prove in court? That DPP did not enforce all the laws. And for you folks to say that, because I didn't call Dawn Apuna dumb. I didn't.
Thank you for your testimony.
Chair.
Thank you for your testimony. We're going to move on to the next testifier.
Please. Why don't you ask me some questions?
Members, are there any questions? There are no questions. Clerks, we're moving on to the next testifier. Leslie Among.
Chair, testifier is not logged on.
And clerks, could you just flag if Leslie comes on that we are going to take the testimony at the end of this the hearing?
Yes.
The next testifier is Kira Fualau Toalasi.
Chair, testifier is not logged on.
Okay, again, I would like for you to flag that individual's name because I would like to allow them to testify. Clerks, is there any in-person testimony in the council chamber?
Chair, there are none.
I have to ask, wait, let me go through the in-person testifiers first because they were the ones who had registered. Okay, is there anyone else in the council chamber who would like to testify on this item? Please come forward to the testifier podium and begin by stating your name.
Good morning, committee chair. My name is Eric Robinson. My law firm represents Malka Warriors Luau. Thank you for the opportunity to hold this informational briefing today. I don't want to reiterate all of the points that were just discussed. There's clearly a lot of emotion here, but I do want to provide an update on where the luau is in terms of how they're responding to DPP's enforcement. So they've been actively working to either achieve compliance or relocate. And as of today, the luau has stopped online ticket sales beyond mid-January, and they're planning to, around that date, either shut down operations or relocate. So just wanted to provide the committee with that update about what they're trying to do proactively to resolve the issues that have been raised by DPP, to resolve the issues that have been raised by DOH, and to make sure that they are achieving compliance with all the permits and regulations they're required to have. I'm happy to take any questions the committee may have.
Members, are there any questions? And Councilmember Wire, since this is in your district, I defer to you on any follow-up you may want to have with any of the testifiers.
Appreciate that, Chair. I think till this time, I think the facts and what's going on has been pretty clearly laid out, and appreciate all the due diligence and welcome, of course, input from the community. But of course, as we've continued to relay to anyone that's asked, you know, ultimately any violations of our LUO, whether they're in KUNIA or, on North Shore, that those all get referred to DPP for investigation. I know our investigators at the city have been responsive and go out and do look at potential violations. And that's, of course, outside just this particular situation. And so I'm extremely grateful for all the hard work that's been going on, right? And of course, understanding we're trying to correct a lot of issues in our community, can say that just, particularly with Director Apuna, have been extremely humbled by the way she engages with our community from Waipahu to North Shore. I know that we ask a lot of her, and she's always there and ready to show up and responsive. Appreciate you being on the call yesterday with OCCL and AGs and our state delegation regarding the homes on North Shore. And, these issues, constantly providing updates on the Avocado Street property in Wahiawa, responding to constituent emails directly, into the late hours of the night. And so just appreciate you always being above reproach, accessible, honest, and extremely qualified, with both your planning background and legal education, and then having also a new deputy director alongside you with an engineering background. I think just, of course, being in this position only a year and a half, and don't want to comment on past directors, but can say, and seeing who's leading DPP now, I think we're so well positioned to take the city forward and take our community forward. And so mahalo for all your work.
Thank you,
Chair.
Councilmember. Clerks, do we have any other, or is
Chair,
there,
could I ask a question?
to the testifier?
Yeah.
Okay, sure.
Quick question. So you said the online tickets have ceased into mid-January. When is the last time the luau will be operating in this year, in 2024?
Is this, okay. So right now, because they've got so many employees and so many contractors and vendors they're working with, so there's more than 70 employees that the luau employs, dozens of vendors. It's not a matter of just simply pulling the plug, unfortunately, so they are trying to balance the realities of their obligations to their employees and customers with this. So we're targeting that mid-January date. So whether it's stopping there or relocating to new position, that's the date that we're looking at right now.
Thank you, Chair.
Members, any other questions? Councilmember Okimoto.
Thank you, Chair. Hello, good morning. So just to clarify, currently the luau is still operating. It's still open.
That's correct.
And you said that they're stopping online ticket sales partway through January. Why, if they're not in compliance right now, why are they continuing? Why do they not cease to operate?
So there are a number of points that we have some slight disagreement with DPP on with regards to the enforcements they've taken. One of the key issues of that is the particular use that a luau falls under the land use ordinance. We have made an appeal to the Zoning Board of Appeals that flowed from the notice of order that DPP issued on that. That's currently set for contested case hearing in January of 2027. So that's obviously not something that's going to be heard before, but we are working to address and respond to DPP's enforcements.
And currently the luau is being operated on ag land.
That's correct.
And the plan is to just wait until January until you find someplace else to go, or decisions are changed, or because it's on ag land, so it shouldn't be operating on ag land from what I understand.
So they're in the process of either winding down to either stop operating there or relocate. So they've got a number of sites they've been looking at, submitted RFPs, waiting to hear the response back on that, whether or not that gets awarded. But the process, again, isn't something that just happens kind of at the snap of a finger.
Who's deciding on the timelines for this? And you said they're in the process of looking, and you said that in mid-January is when they're going to stop online sales. Are you guys determining that, or is that being decided by DPP? And what timeline you have to look for someplace else or to continue to operate or cease operations?
So part of that's influenced by the other sites that are being looked at. For example, where an RFP has been submitted, we're hoping to have the decision on that soon. We have not received that decision yet. In terms of that particular date, there are a number of existing tickets that have been sold that kind of gets all the employees, all the vendors, all the contractors through the busy holiday season so that they're not, being put out of a job right before the holidays. So that is factoring into
Definitely.
that.
We are not looking to have people not employed, especially our local residents, but I want to make sure that we're doing this properly. I'm just curious. I was just interested. It seems like you're dictating the timeline right now, and that's interesting to me, based on whether someone else is able to take on the luau somewhere else.
Sure, and I appreciate that concern. We're not trying to dictate the timeline, but we are trying to balance the tough position of, doing what DPP's asked, making sure that the luau is able to represent and stand on its legal rights and its constitutional rights, but also making sure that they can do right by their employees and their contractors. So as the managing director stated, I believe DPP is looking to judicial enforcement. Obviously, if a court order comes out and says, stop operations, notwithstanding some appealable issue, I don't think we're going to be, in contempt of court and not stopping operations if that's the case.
Sorry, Chair. So I want to continue just a little bit. So you care about the employees, but let's say in the event this cannot continue, you don't find another location, then what happens with the employees? I feel like there might be some taking advantage of the zoning appeal process right now, and you just deciding how you're going to arbitrarily choose a date, when to operate and when to not, based on whether you find someplace else to relocate or not. That's concerning to me. And if you're talking about our employees, what are the local employees, what's happening to take care of them in the event that you have to close down? Is it just a Band-Aid till January? What's going to happen after that?
Sure, so I think that's probably a question that's best addressed by the luau's president, Kiri, who is here, if I can have him come up.
Good morning.
Good morning. My name is Kiri Fualauto'alasi, and I'm the president of the Mauka Warriors Luau. And I'm from the community. I live in KUNIA. I guess you have a question for me. Can you ask that?
Well, I was just curious because I heard your representation say that you're going to stop online sales after January. You're not taking anything else after that, but you're taking some now, and the purpose is to make sure that your employees are cared for. And of course, we want to take care of our local residents and their jobs. But I am worried that it seems like there's arbitrarily dates chosen, and you're on ag land, so from my understanding, that's not appropriate. That's not allowed. So in the event of you trying to figure out, can you relocate or do you remain? I'm just trying to understand, what is your plan for the employees? I do have concerns that it seems like you're just taking advantage of the process right now to extend your operations or hours, you're being able to open and operate. And in the event where you have to relocate, what happens to the employees then? Or you have to close down, what happens then?
The worst case scenario, if we have to close down, it comes up to losing jobs. But we're here to make things bono, to make things right. And we are working right now, and we do have places we're looking at. We're about to sign a contract. It's just a matter of, okay, is that worth it? Because some places are actually offering things that you may as well own the luau yourself. We can support. And for how many people that we're getting right now, you can look at the petition. All right, that's not it. It's more than 200 people relying on us, local businesses, catering companies, and all that. My gut is telling me right now, yes, shut it down. But what's going to happen to people that actually did? Here's the most frustrating part. Mr. Burke was the general manager of the place. And for a dumb local kid like myself that's trying to make build a business, I'm not from the mainland with a corporate office. I have the talent, I have the market. We approached him. He was the general manager of the place. Nothing can be approved without his signature at the time. So that's the problem right now that we're dealing right now. I have a lot of followers. You can see families over here and my kids and my wife. Yeah.
Well, I just want to make sure that you understand, I'm not in any way trying to have your family or anyone hurt, but I do want to make sure that we're doing things legally and in the right way. So just moving forward, I think it's just to be mindful of the processes that will be taken and not take advantage of, especially the zoning appeal process. But I hope that you can find someplace else to locate, because I have always been a supporter of local businesses and employing our local residents, but we want to make sure that we're following the law and doing things properly.
Yeah.
So thank you for being here and testifying and answering my questions. Thank
Any
you,
other
Chair.
questions by members before I move on? Councilmember Wire.
Thank you, Chair. And I'll go back to your representation, and just wanted to maybe flesh out a little bit more. And mahalo for coming down and testifying. So could you walk through a little bit with more specificity what your perception is of what the LUO allows and what the contention is and what you're appealing?
Yeah, so luau is not a defined use under the land use ordinance. So DPP's position has been that it is, I believe, an outdoor recreation activity. In our petition with the Zoning Board of Appeals, we take the position that it's an outdoor amusement. I'm sorry, opposite. Let me pull up in the NOO, just so we've got that. Bear with me.
And if you don't have it, I don't think we need to spend too much time diving into it, but I think we're going through this issue in other areas of the district, including all over North Shore. And I think even in neighborhood board, just the discussion of enforcement came up, right? And DPP is doing their best to go out and identify violations of the land use ordinance, right? And then they cite and they do the NOVs, and in this case, also the cease and desist letters. And then, of course, there's a legal process that a particular operator or landowner actually would be able to appeal to the Zoning Board of Appeals, which you had mentioned earlier that you did. Is that correct, or that the landowner did?
That's correct. And to correct my previous statement, the NOV that DPP issued says that luau's are considered an outdoor amusement facility. And the position that we took is they more closely align to the definition of an outdoor recreation. So since we don't have a clearly defined use under the master use table and in the land use ordinance, DPP looks to generally what aligns most closely with an identified land use. So we're having a difference in interpretation of where a luau most closely aligns.
Okay, appreciate that. And I'm assuming along with notice of violations comes fines. Is that your understanding?
That's correct.
And of course, if you succeed on appeal, you wouldn't have to pay those fines?
So the fines continue to accrue while that appeal process is ongoing. If we ultimately prevail, I believe the fines would not be in effect. I'd ultimately defer to DPP to speak to how they enforce that. But if we did not prevail, I'd expect the DPP would still be seeking fines for the violation.
Correct, and that would make sense. And so appreciate that understanding, because ultimately, as I mentioned earlier, I won't go on too long, Chair, but just to comment that we get tons of LUO violation complaints at our office. I think just given the nature of our district. And our policy is just anything that comes in goes to DPP, because we have to be fair, right? Because once someone starts talking about their neighbor doing some permitted work, and then that neighbor reports their other neighbor for having rocks on the unimproved sidewalk, like it just creates a whole mess if we're dragged into mediating. And I also don't think it's appropriate for me as the person that's represented the entire community to throw my power and weight around and intervene in a legal process where everyone has rights and expectations in Kuleana. And as long as everyone is operating how they should, which in this case DPP is enforcing the law and following the legal process, I think that it's appropriate for us to allow that process to go through. And obviously, the expectation of anyone would be to comply with the law. And so my hope is that however this is resolved, that everyone walks away from this and our community walks away from this in a good space. So thank you, Chair.
Thank you. This is going to be the last question from a council member on this for this testifier. Councilmember Tupola.
Sure. Thank you, Chair. And thank you, Councilmember Wire, for your thoughts. Agreed. So there's 4 specific things brought up from the alcohol licensing to the wastewater DOH violation, of course, what you're talking about with operations and then illegal structures. So with these 4 different issues, are you guys going to resolve any of these immediately, or is all of these just going to continue on until January?
So the luau is making efforts to resolve all of those. Whether or not that can be achieved, we'll see. But they're not simply just sitting there. I don't think it's a matter of them not being enforced. I don't think it's a matter of them being ignored or thrown to the side, I think as some have hinted at or alleged. So they're being taken seriously and they are being worked on to be addressed.
What is the amount of fines that are accruing daily?
I don't have a total amount, but I can get that back to the council member if you'd like.
Okay, thank you. Thank you, Chair.
Thank you. Is there anyone in person who would like to testify on this matter? Clerks, do we have anyone else remotely who would like to testify in this matter that has not testified at this time?
Chair, I see some raised hands online.
What are their names?
Karen O'Mahony.
Karen O'Mahony, are you testifying on this matter?
Yes, thank you. Shall I start?
Yes.
Okay, so I don't actually have information particular to this item, but I did hear something very concerning coming from an official earlier, and that was that questions would not be answered by someone who had criticized there was like personal offense taken because someone was accusing
Karen, I'm
people of
sorry.
being,
That's listen. You need
or doing
Karen.
bribes.
I'm sorry. You have to testify on the matter at hand. This is not to come in and having a discussion.
Okay.
On what
The matter at hand, I don't think. Okay, I don't want to have a discussion. Thank you. I don't think it's at all appropriate for members of the government to say we're not going to answer your questions because you have criticized us, whether it's valid or not. And that I want citizens to be able to point out all violations that they suspect, whether or not
thank you for your
people
comments.
like to be criticized.
Members, we are going to move into questions for the administration. Are there any questions for the managing director on this agenda item? Councilmember Okimoto.
Chair, just either a managing director or director.
Either the managing director or the Department of Planning and Permitting, either one.
Okay, thank you. Good morning, Director Formby, Managing Director. I wanted to clarify, I know that the representation of the luau just mentioned that the land is under his understanding with the LUO that they are able to operate an outdoor activity. That's not my understanding. Could you clarify that? He's saying that his interpretation of it is that the luau can operate as an outdoor activity on ag land.
Good morning. Mike Formby, Managing Director. So DPP has taken a formal position that it is inconsistent with the classification of the land. In fact, they have sent a letter to the Land Use Commission as required, alerting the Land Use Commission to the inconsistent use. The operator has availed themselves of their rights under the law to appeal that determination. But from DPP's perspective, we don't believe that it's a colorable argument. We believe that it's an inconsistent use.
Thank you for clarifying. That's my question. Thank you, Chair.
Councilmember Wire.
Thank you, Chair. And just quickly to follow up on that, thank you, Managing Director. And I would say it's probably not an uncommon occurrence either that we have folks that argue or say, hey, this does comply, and then DPP is like, no, this is what the law is, and then they appeal, and then they wait for the outcome, and then maybe they, and I'm thinking of examples in our district and other places too, but continue on and continue to accrue fines. I mean, is that kind of oftentimes what bad, or folks will do?
Perhaps, and I don't want to speak to whether or not that tactic is effective. We're continuing with our enforcement, and so internally, after issuing the notices of violation, which became notices of order, and with the letters, which are orders of cease and desist, then we will enter into a court process to enforce. So I think you heard the operator say that he believed that certain representations were made by Mr. Berg on behalf of the Hawaii Country Club. What the administration has chose not to do is get in the middle of that dispute. So if the operator is going to have claims against the Hawaii Country Club for being told that they could operate the way they're operating, we have chosen not to get in the middle of that dispute. And I don't think it's a good use of taxpayer funds to do that. So we're going to proceed with our interpretation of the law, that we believe it's an inconsistent use of ag land, and we'll initiate the court process and we'll let that play out. And both the country club and the luau can come and present to the court any information that they want. But we're going to enforce in a way that I think is efficient, effective, and at least cost to the taxpayers.
Appreciate that. And so what I'm hearing is, to the extent that there is a violation of the law, there will be consequences, and that applies universally to other locations as well, or folks that violate.
That's correct. And we've said all along, and I put in email, that the city's position is we hold people accountable. And that's what we're doing in this case. But we're choosing not to get in battles that are not city battles.
Thank you. Thank you, Chair.
Thank you. Members, any other questions? Councilmember Tupolo.
Hi, Managing Director. Thank you for being here. A follow-up, you just said that they had forfeited their right to appeal, but earlier there was a statement that there is an appeal that should be heard in January. So are those the same appeals, different appeal, or is there no appeal in this case?
There is a contested case hearing, but I don't recall saying that they forfeited a right to appeal. I don't recall saying that.
So basically their contested hearing is about appealing the inconsistent use that the city, no.
It's not appealing the inconsistency, it's appealing the city's interpretation of the ordinance and the law.
Oh, it's about the definition of the use of the land.
Correct.
Oh, interesting.
So
Okay.
Dawn, you want to get more specific?
Thank you, Dawn Takeuchi Apuna, Director for DPP. So from what I understand, that the luau is appealing the notices of violation, and so they're challenging the interpretation that DPP has taken that the luau is not an allowed use in the ag district.
Director, do you know how much the fines are accruing daily?
So there's various violations, $1,000 per day for the luau, $50 per day for the other building permit violations. So I'm sorry I don't have the totals, but there are various ones dating back around May or so. So they are accruing daily, and they will continue to accrue as we move forward, as the Building Board of Appeals hears the case. So they will, yes.
I mean, it's worrisome, right? Because January is so many months away that accumulation of a violation would just be huge. And I think hinging everything on a decision at the Building Board of Appeals is possibly detrimental as well. So thank you for clarifying what the contested case hearing was about. Thank you, Chair.
Thank you.
Thank you. Members, if there are no other questions, we're going to move on to agenda item number 1. We're going back to the agenda. Are there any questions? And clerks, there are no more remote testifiers, correct?
That's correct, Chair.
Thank you. Moving to agenda item number 1, resolution for action, resolution 24-221. This resolution requests that the mayor reconvene the Landfill Advisory Committee to provide transparency and assurance to the public that the landfill site selection process is ongoing. Before we take public testimony, I would like to call on the administration. For the administration, we have Roger Babcock, Director, Department of Environmental Services.
Good morning, Chair, committee members. Roger Babcock, Director, Department of Environmental Services, which is in charge of refuse collection, treatment, disposal, and the landfill. So as noted in the resolution, the administration in early days of administration in 2021 formed a landfill advisory committee to assist with selection of the next landfill for the county. That committee met, had 8 public meetings, and concluded their work in June of 2022. So at this time, that advisory committee doesn't exist anymore. the meetings of that body were all public meetings, and it take quite a bit of time to put together, and it would be quite an effort to reconvene that committee. Since then, the city was requested and granted an extension on the deadline to name a new landfill, and that was recently approved by the State Land Use Commission in August, giving us until December 31st of this year, 2024. That extension requires quarterly in-person updates in person to the Planning Commission, and then sending the report to the Land Use Commission as well. We just did that update last week, September 18th, to the Planning Commission. That was a public meeting, and the presentation is on the record, as well as the minutes of that meeting. So the update is that the administration intends to name the new landfill site before the deadline, before the end of the year, which is within just a very short time, a little less than 3 months. And so the administration's position is that it's not needed to reconvene the advisory committee, and we're in the final stages of naming the next landfill site. Happy to answer any questions that you have.
Before we move to questions and discussion, I would like to take public testimony. Proceeding first with in-person testimony in the council chamber. Clerks, do we have any testifiers for this item?
Chair, there are none.
Is there anyone else in the council chamber who would like to testify on this item? Please come forward to the testifier podium and begin by stating your name. Seeing none, proceeding on with remote testimony. Clerks, do we have any remote testifiers for this item?
Chair, there are none, but I do see raised hand by Chun James.
Chun James, aloha and good morning. Would you like to testify on this item?
Good morning. Can you hear me?
Yes, please proceed.
Thank you. I just wanted to interject again here that we really need to plan 7 generations ahead. And I don't see how we can keep duplicating landfills in our teeny island of Oahu. And so it behooves us to really shift our mindset to do way much more recycling than we are doing now, because we just simply cannot duplicate landfills over and over again, because how many landfills can we continue to duplicate on our small island? And our water aquifer is just life to us. We need to have that. So I strongly encourage the city to look beyond the idea of creating another landfill, but to gravitate to other technological system to do it, because there are a lot of other countries who are doing it without having to keep creating new landfills. So thank you very much. Keep up the good work.
Thank you, Chun. Is there anyone else standing by remotely who would like to testify on this item? Please use the raise hand feature to indicate your desire to speak. Clerks, are there any others?
Chair, there are none.
Thank you. Members, we are in discussion. Are there any questions for Director Babcock? Councilmember Tupolo.
Thank you so much, Chair, and thank you for hearing this resolution. Aloha, Director. How are you?
Great, thank you.
Thank you so much for being here. You know, as I prepared this resolution and thought through the fact that I've heard the Planning Commission meetings, I know you guys are supposedly on set to announce the location. You know, the main thing that the community is concerned about is that there is no public discussion specifically about this. So I know you said the Planning Commission is a public meeting. I understand that. The discussions that we have at the Landfill Site Selection Committee meeting are specifically about the landfill, and even after the site is determined, even after that, There will be many years of preparation. There will be many years of transition. There will be many years that needs to, the public will need to weigh in on how things are going, because this is a public landfill and it is going to affect the public. So regardless of whether or not there's a new site announced, that is not the concern of my community. They're not concerned that we're twiddling our fingers in Waianae wondering what the new site is. We're wondering what the path forward looks like. I just came back from Hongmiaoling, a waste treatment plant in Fuzhou, China, and they don't do landfills and haven't done it since 2009. Haven't done it. They create 30,000 bricks a day of fertilizer, biofuel, energy, everything. Every single part of the process has a byproduct, and they're able to suck out the methane. The whole process is airtight. So the question is whether or not we can have public conversations about exactly what Ms. James brought up on whether or not us choosing a landfill site is really the path forward. Yes, name it. It's not going to happen the next day. It's not going to happen the next year. There's going to be a process. But what do we do in the interim as we move through that process and we determine that there are better technologies and that we should be moving in a direction where we don't have to continuously name sites? So my concern is not creating a landfill advisory commission just for the fun of it so that we can duplicate whatever's happening in the planning commission. It's so that we can have these ongoing conversations about what we are doing with waste in the city and what the process of transition will look like. Is it correct to say that after the site is announced that there will be a transitionary time period of which there would have to be, I don't know, maybe 5 to 7 years before it's actually into the new site? What does that transition period look like for time frame?
Thank you, Council Member, for the question. So I guess I would say that yes. So the first part of the question is there a transition period? And yes, there is. So the identifying the site is just the first step. As you know, then there will be a long public process. There'll be an EIS that has to be conducted. There'll be there's a lot of public interaction in that process. And so that will take some time. In addition, there will be other steps along the way to get to siting and opening the next landfill. The responsible thing for the city to do is to have a landfill. There may be a time in the future when what goes into a landfill is very, very minimal, even more minimal than it is now. Currently, we have about 88% diversion, so only about 12% of what needs to be disposed of on the island, that's generated on the island, goes to the landfill now. The rest is recycled or minimized by making ash and electricity and doing a lot of recycling programs. We have many other recycling programs in the works that will divert more out of the waste stream, including food waste is the next one that's coming up per ordinance from council, food waste and compostable materials. That's under a contract has been issued on that, but that new facility has to be built before we can
Director, what is the transition period going to look like? 5, 7, how many years?
Oh, okay. The transition period, from prior work with Land Use Commission, it's been stated that it would take approximately 6 years to open a new landfill, but there's a big variation in terms of a lot of things can happen along the way, so it is possible that it could happen faster than that, and it's also possible that it could take considerably longer than that, depending upon what happens during the transition process.
So aside from the statement you made that it might be hard to reconvene the committee and it might be laborious, are there any other reasons why we shouldn't reconvene the committee during that transition period so that we can keep the public apprised?
So the Landfill Advisory Committee charge was to select the next landfill. So once we've done that identification, then they are not needed in that transition period.
I understand that that was their charge and they came up with no sites and then you guys took on the task. My question is, as we move through this, the planning commission that we have, their sole responsibility is not to report on the landfill. Their responsibility is to do many items that come in front of them that are planning related, whether or not it's items that need to be brought to DPP or bills that are coming to us. So is there any harm in us having a public process whereby we can have public discussion specifically about the transition? Because as you said, it could take longer. It could be slower. There could be bumps in the road. It won't just be citing the name of the landfill. There will be many things that the public will have to weigh in on and know about. My concern is that as we move through this, I don't think that quarterly at a meeting that's not about this is going to be sufficient for my community to know that there is actually forward progress on this item. It is an advisory commission. It is a way for us to have discussion. So respectfully, I think it's not hurtful. I think that this process is not as easy, and it's actually one of the most important processes that we do in the city. Take care of waste of over 1 million people. So I think that the concern of our community, since we've had every single landfill from the beginning of time, is whether or not this is actually going to happen. So that's why we want a public forum for us to have it. And again, we can change the charge of the landfill committee and make it not about site selection, but about updates on what the transition is going to look like. But it will be a specific time period with people that are chosen that might have the background to make sure that we're keeping the public appraised of how the process is going. So I just want you to know that that's where I'm coming from with this, is that I do know that you guys are trying to make forward progress, but this is something that is going to affect the public heavily, specifically my district.
Yes, thank you. So one thing that doesn't end, so our quarterly reports to the Planning Commission are required until we name the new site, and then that ends. However, we do have semi-annual meetings in the community on updates. That's required, another requirement, until the new landfill is opened. So we do have those quarterly semi-annual meetings on progress with respect to H-Power and the landfill, and those will continue to occur. So that is a forum where, and our reports that are online for those that can't attend, for all of those quarterly meetings that have happened since 2019 when the decision in order about
I'm aware of what those meetings are like. I've attended all of them. I know what they're like. I know how the public can testify, but it is not the same thing as specifically handpicking people in the community to care and bring insight into this process so that we know that there's more than just a few people making decisions about this. So I thank you, Director, for all your work. I really do. I support you guys, and I know that you guys supported me heavily in my last cleanup, and I'm very, very grateful for what you do for the community. Thank you, Chair.
Thank you, Councilmember. Before I call on Councilmember Wire, Director, what City Council committee has kuleana over your jurisdiction?
For
your department. And the reason I'm asking, I know that, you know, budget covers, of course, the budget part, and the reason I'm saying this for Councilmember Tupola, similar to what I do with the Department of Planning and Permitting with regard to periodic updates on improving the permitting process. Perhaps it would behoove all of us if you would provide more timely updates on what is going on publicly and at an informational briefing. It could, so do you know what committee?
PIT, I guess normally would be.
And can you, for the public, what is PIT?
Public Infrastructure and Technology.
Okay.
Yeah.
Or it could it could be any of our committees, but I guess I'm thinking that perhaps you should be coming on a more timely basis to provide updates. And Councilmember Tupola, you could even invite a lot of the community and everyone, and it could be on an ongoing basis. I'm just giving that as an alternative.
I agree, and it is my committee, and we can have that. My concern is that the shaping of the decision forward is not part of us. Meaning that there was a time where the community was weighing in and we were helping to shape the forward progress of it. Now we are not. Now it is solely an administrative decision, administrative executive moves that we just get updates on. what I really feel like an advisory committee did, because the people that came from there, I knew them personally. I knew their background. I knew what they cared about with waste treatment. They were bringing in insight so that we as a city were making better, well-rounded decisions and not independent decisions of what was affecting the community. So I agree we can have updates. My concern is that a actual committee would be able to give us insight on how to make the decision, not just what is the outcome of your decision, but what did we make the decision together as? Because that is my concern. We don't want to be part of the end of hearing what the decision was made. We want to be part of the front of how the decision was made. Thank you, Chair.
Councilmember Wire.
Thank you, Chair. And kind of going off of what Councilmember Tupolo was saying, and also Ms. James, what are some of the ways, I'm kind of curious on the updates on some of the projects and ideas that have come up with, like recycling. You know, I know there's been talk about how you can maybe use ash for construction materials. I know the composting conversation is going on, which I think there might be some issues with DOH. I'm not 100% up to date on that, but with the PFAS and, you know, just other things we should be looking at or could be looking at.
Yeah, thank you for the question. So as you mentioned, there's a few different efforts underway. One is with respect to green waste. Green waste may be, according to our waste audits, up to 25% of the material that goes into the gray carts now, which goes to H-Power. That will be soon be diverted to the composting facility, along with manufactured compostable materials. And that's per ordinance, right, that was updated last year. And so that's well underway. The contract has been issued to the contractor through an RFP process. There was a bid selected, and but that did require a construction project. So the vendor, the contractor, is getting their permits, both from Department of Health and from the city planning and permitting. Prior to starting construction. So construction on that new process has not quite begun yet. But at that time, then we'll be diverting, we'll be able to make more compost and recycle the materials as opposed to converting them into electricity and ash. We have a e-waste contract, RFP about to be issued soon. That will service both city operations directly with bins and pickup service available to the Civic Center and other city facilities, including Honolulu, et cetera. And it will also involve the convenience centers, so public can drop off at any convenience center e-waste. And then it will be recycled through a vendor. And so that we're hoping to issue that contract very soon and get it awarded before the end of the year. So those are two big things. The other big thing is the ash recycling project, which you mentioned. It's been an effort that's been going on for a few years. The contract has been awarded. It includes the planning, design, and construction. Planning's done, design is nearly done, and they have submitted for their permits that are required from the Department of Health. Those permits have not been issued yet, so we are not doing a notice to NTP for construction until we know that that the permits are in place. So that process, we actually don't have a good estimate on when that would be done, but it has been and lots of meetings with the Department of Health on that, and it's been ongoing for actually approximately a year. So we anticipate, hoping that will happen soon and we can get that project going. That's a very exciting project, would divert up to 70% of the ash, would not need to go to the landfill, and would instead become a recycled material, which would be destined for asphalt paving. And that's a process that is done other places. So it's not a new thing in the world or even in the US. So we are very excited about that. In addition, we have as part of our integrated solid waste management plan, we did put together a committee, which was, now I'm going to try to remember the name. It's a waste diversion working group. That might not be the exact name of it, but it was a working group that met multiple times, did have a panel of committee members that were appointed by the mayor that sat on this thing, and they had multiple meetings, and they came up with a set of recommendations of other waste diversion activities that we can do. And one of them was e-waste, and we're acting on that. One of them is is construction and demolition waste. And so we are proceeding with looking at that. At the same time, we are in the process now of looking at the future of H-Power and what that's going to look like. And that does involve alternative technologies. And so we are very much in line and investigating those alternative technologies and what will make the most sense for the future, for when H-Power is gradually reached its useful life and is no longer economically feasible to keep that running. So that is definitely all going on in our long range planning. So,
really appreciate that, and that's actually all exciting stuff. So looking forward to that. Just one last question, Chair. Because I know Chair Kane from Waimanalo Neighborhood Board brought up the committee yesterday, like not having a recycling facility on island. How does that all factor in? I mean, I know some of this is kind of recycling the ash, but if we're thinking like the standard, right, everything that goes into the blue bin, does that kind of get worked into, goes to ash for recycling into the construction, or is there a contemplation of like reusing glass? I know folks have talked about glasses, sand replacement, right? I'd say golf courses or whatnot, and all of those items. I mean, or is the goal to transition all that stuff over to compostable, where like all the cups we get at the restaurants are compostable, so then it all goes to the composting facility? I mean, do you have any insight on that or what we could be sharing with the community?
Yeah, it's a good question. Thank you. So there's, as you mentioned, there's different ways to recycle different types of materials. I think the goal in terms of compostable materials would be to get them into the compost. Compost then is a valuable product for agriculture and golf courses and other use, even in individual homes and stuff. So that is a really good way to recover materials and put them back into use here. So generally, I think we would like to do things, our focus would be things that are recycled and reused in a way locally, right, as opposed to importing materials that they essentially replace, because a lot of compost, most compost, is imported, but we also make it here, and that all gets used. But now when we make more compost by diverting more there, food waste and compostable materials, then we'll make more compost. And so that would mean less imported compost and more of our materials recycled. So I think that's what you're getting at. Other things, the markets for them are on the mainland, so that would be glass and certain types of plastic, aluminum, newspaper, and things like that. And those things will continue to expand the amount of things, and e-waste is one, so we should be no longer sending e-waste, and we will ban e-waste from going to H-Power. Currently, what the guidance is on our website is it goes in the gray bin, and it goes to H-Power. So we hope to be changing that very soon. And so, and we are continuously looking for ways to recycle more and more things. And we do have a recycling branch within our refuse division, and that is basically all that they do. We also do a lot of public education. There's a great Hawaii Theater for Youth program called Opala Remix, which goes out to multiple elementary schools every year. It's a fantastic show, and it really is educating our youth and thinking about recycling and getting that into the psyche of our keiki as they grow up, and it will just be natural for it to do as much recycling as possible.
Appreciate that. Who knew waste could be so exciting? Thank you, Chair.
And I remember the name of our group. It's called the Source Reduction Working Group. Sorry, Chair.
Okay, thanks, Councilmember. Director, you know, for the parameter of lands that you're looking at, I keep on hearing federal, and, you know, the state has a lot of land, and I'm assuming you're looking at private. So with the parameters of lands, could you just reiterate what is the scope? I know we don't have too much county lands, nor are they probably conducive, but I want to know, are you looking at federal, state, and private lands?
Yes, thank you. Thank you, Chair. Our most recent, the results of our Landfill Advisory Committee were that there were, because of the restrictions of what's known as Act 73, there are federal regulations also, which are FAA related to airport buffer zones, tsunami inundation zones, and then there are state regulations with a residential, hospital, and school buffer of a half mile, as well as all conservation lands are not allowed. And so it doesn't matter who owns those lands. If they fall in those zoning districts, then it's not acceptable. In addition, there's a restriction from the Board of Water Supply called the no-pass zone. And so I think our folks are familiar with many of those things. So those allow us to do GIS maps of what space is still available. And we have and are looking at all of the remaining available space. During the Landfill Advisory Committee work, we had excluded all federal lands from their consideration, because there are federal lands that do meet all of the other restrictions that would be not restricted, except for that they are federal lands. So those were excluded because of, in the past, it was difficult and a long time consuming to be able to get those, potentially use those properties. And so when the Landfill Advisory Committee asked us to, when they decided not to select any of the sites that they were evaluating, they said, go back and look at federal lands, and also go back and look at what if we modified Act 73, which has the residential buffer and the conservation district buffer. And so that's what we've been doing since they finished their work. And as you know, the military sites have all been rejected by the military. So those sites are no longer under consideration. So specifically the federal lands. There are properties, both private and city properties, that become available or unrestricted if we go back to the legislature and ask them to reduce the restrictions in Act 73. Specifically, if we reduce the buffer from a half mile to a quarter mile, then what happens is there are several sites that become available. And those sites are in the report that we gave to the Planning Commission, but basically there are 4 new sites that become available. If you also then, if you take away the buffer entirely and take away the conservation district requirement, there are another 6 sites that become available. And when I say sites, I mean land where there's 100 acres that is unrestricted. It doesn't mean it's necessarily a good site. There are additional evaluation that has to be done about them, about slope and what's current use, ownership, various other issues about what would be required. So that's the evaluations that we are doing right now. We're very close to finishing it, and we'll be,
Yes.
We have a consultant that's working with us.
Got it. It would have been nice to have handy those 6 sites. I know we can get it, but it would have been handy today. And of those 6 sites, what is the status of the land? Is it government? What is it? City, federal, private? What are the status of the 6 sites?
So there's really 10 sites. There's, let's see, so privately owned, there would be 1, 2, 3, 4, 5 that are privately owned, some that are state owned. 2, at least 2 or 3 are state owned, and at least 1 or 2 are privately owned.
What? That doesn't add up to 10.
You said 5 private.
Let me check the private, sorry. Some I'm not 100% sure what the ownership is.
Okay, but you're looking at private and state. Okay.
Private and state, yeah.
Got it. Okay. I need to bring myself up to speed as well. And because I do share the frustration of Councilmember Tupola, just with regard to the burden of the people of the West Side. And I think that everyone would like to come to closure on this issue with the selection of a site. My second question is, Councilmember Tupola had said that she was open to the scope of this advisory committee rather than identifying and rank potential landfills for the city's consideration, probably broadening the scope. After the site is selected, would you be open to such an advisory committee?
So once the site is identified, then we actually already have a contract available to give notice to proceed to do the environmental impact statement, and that's a long study. There's a contractor required to do all that work. As part of that, there's a public process. In addition, we will be looking at, then we would be focused on one site. We'd be looking at procurement. We'd be looking at design and basically planning and design to do construction. Those are all processes that are done, by consultants and professional services. There really isn't any advice needed on proceeding with those things.
Okay. Actually, members, I'm going to come to closure on this issue because we still need to move on to another agenda. But I would like to provide Councilmember Tupola as part of kicking off our comments before I make my decision.
Thank you.
On just, explaining why you introduced it, and after you've heard what you've heard, your thoughts.
Yeah, no, thank you, Chair. First off, what you just said about state and private lands, 5, 1, 2, 3, which was very unclear to me. For me, that's the first time I've ever heard that. Secondly, it wasn't clear enough for anybody to really understand what's going to happen. Also, in Act 73, or the repeal of that, say, for example, you are choosing some of the sites that require a state legislature to repeal part of an act. That's not going to happen until the end of May. And what happens if that doesn't pass the legislature? So are we going to name a site that has to go through a process through the ledge that might not happen, and then it takes another year? Respectfully, Director, I understand how complex this is. That's why I'm trying to be realistic. Realistically, this is going to last a while. Realistically, the community should always be advising, hands down, even if there is a consultant. So I feel like it would behoove us to get in front of this instead of be behind of it. We just disclosed publicly that we're not sure if it's 5, 1, 2, 3. That's not good. That's not good. And it's not good for us to find out in December what all the sites are and that some of them might require legislation. So respectfully, I think that it would not be hurtful. It would not be harmful. Because even if you have consultants, the fact that they would have 8, 5 community members giving them insight around the edges, it would help the consultant actually. It would help them to know things that they might not consider, like that people in my community don't want that to be repealed. So again, I don't want to do anything that is going to harm your operations. I appreciate the things that you do. I can't iterate how much I'm grateful for ENV. I don't think that this is going to hurt. If we reconvene this committee after the site selection, there'll be at least 7 years of discussion. I think that it would be focused on what we needed to be focused on and have that input as you guys move along, which would really help the city to not have to handle attacks after the fact. So personally, I think it would help to have it. But again, thank you for all that you have done for us and continue to do. Thank you, Chair.
Thank you, Councilmember. Sir, would you like to testify on this matter?
Hello, my name is Austin Salcedo from the West Side, District 8. Yes, Director Babcock, we need to continue the dialogue with the West Side community because we have been dumped on for centuries on this thing, way too long. And the discussion needs to go on. We don't need a dialogue or a document to say that it's already been done deal already. We need the advancement notification of what's going to happen because this thing's supposed to be out of our district area already. The PVT, our landfills. This Waianae Valley had one landfill. Now we got Waimanalo at Kahi Point landfill. People at PVT area, the surrounding community area is suffering the the effects, the ill effects of the airborne contaminants. And they've been voiceful. You need to come out. I invite you to come out to our neighborhood boards to share again your incentive, ideas, creativity, and this type of people that you're inviting, contractors, whatever, and the targeted sites that your folks is going to implementing this so-called next landfill. But it needs to be removed out of the west side immediately. So I invite you to the neighborhood board for a discussion. Nanakuli, Waianae. That's where the people is at. People is asking questions. Our Councilwoman Tupola is overwhelmed with this. She don't have the answer because the answers comes out of you, Director Babcock. So I invite you, I implore you to come to the West Side Neighborhood Board.
Thank you for your testimony.
Thank you.
Councilmember Wire.
I'm not sure if Chair's inclination, but I would just bring up for discussion, if we were going to pass it out, maybe there could be council input on who would be the newly appointed members of the LAC.
Thank you for your comments. Any other members who'd like a discussion? I'm actually going to recommend that the action on this resolution be postponed to a date and time to be determined by the committee chair. I am still open to any thoughts just based on the dialogue today. Any objections? Any reservations? Hearing none, so ordered. Moving to agenda item number 2 for action, Bill 64, 2020 FD1. This bill addresses the regulation of uses throughout Chapter 21, revised ordinances of Honolulu 2021, the land use ordinance. Members, I have posted the proposed CD1 to Bill 64, 2023 FD1, which incorporates amendments that were approved by the committee at its meeting on August 22nd, 2024. Members, please also note that as a reminder, and as was done for all committee meetings on Bill 64, roughly 2 weeks before each meeting, I will issue a memo to members about the scope of Bill 64 that will be prioritized and instructions for proposed amendments. As I mentioned and as detailed in Council Communication 237, 2024, and the posted agenda, at today's meeting, I am prioritizing amendments relating to agricultural uses under the accessory agricultural subcategory. As you know, we have already completed industrial, commercial, residential, public, civic, and institutional uses, and agricultural uses under the crop production, livestock and poultry keeping, and agricultural support subcategories. As a reminder, the uses are color-coded in the master use table. Agricultural uses are green. Each use has use subcategories. For agricultural use, the subcategories include crop production, live keeping, agricultural support, and accessory agricultural. And each use subcategory has land uses. For example, livestock and poultry keeping includes outdoor animal raising and confined animal raising. We have listed on the agenda 3 council communications proposing further amendments to the CD1 version of Bill 64, 2023, that the committee approved on August 22nd, 2024. First, we have Council Communication 240, 2024, proposed by Councilmember Wire. We have also Council Communication 241, 2024, proposed by Councilmember Tupola. I have filed Council Communications 245 and 246, 2024, with my recommendations for each line item in Councilmember Wire and Councilmember Tupola's proposals respectfully. Councilmember Wire and Councilmember Tupola, if it's okay, you can go over your proposals in more detail when we get to discussion. My proposed amendments can be found in Council Communication 243, 2024. These amendments would consolidate the biofuel processing facility use as accessory to agriculture activity into the agricultural energy facility use and distinguish it from the biofuel processing facility use as a principal use under the industrial use category. For the agritourism use, refers to accessory destination events, including weddings, instead of weddings and similar accessory destination events, to better cover destination events other than weddings, for example, family reunions, anniversaries, or birthdays. It clarifies that an agriculture farmer's market is an accessory outdoor market for the sale of Hawaii-grown products located on a zoning lot with a principal agricultural use. This is meant to distinguish an agricultural farmer's market from the more commercial farmers markets occurring in zoning districts other than the agricultural zoning districts. It clarifies that one farm stand for the growers and producers of agricultural products is permitted per zoning lot. If more than one farm stand is located on the same zoning lot, it would be considered an agricultural farmer's market. That would require a minor conditional use permit to address potential impacts. For beekeeping, it deletes the beekeeping as an accessory agricultural use and also deletes the related standards. This was also proposed by Council members Wire and Tupola. Beekeeping as a principal agriculture activity would be included in the outdoor animal raising use, and it would be differentiated from accessory backyard hobbyist beekeeping, which will be subject to the animal nuisance requirements, and accessory commercial beekeeping as a home occupation, which will be subject to the home occupation requirements. I will go over these in more detail when we get to discussion, if that's okay with everyone, but I did want to explain the beekeeping amendments before we take public testimony to detail and clarify how those amendments will be applied. My proposed amendments would delete the beekeeping entry as an accessory agricultural use and also delete the related standards. Note that not all accessory uses are regulated as a separate entry in the use table. Background hobbyist beekeeping as an accessory use on the same zoning lot on which the beekeeper's dwelling unit is located will be subject to the animal nuisance requirements in ROH 12-2.5B, which is a separate ROH chapter that covers animals and fowl and is not in the land use ordinance. Accessory commercial beekeeping as a home occupation in zoning districts where home occupations are permitted will be subject to the home occupation standards in ROH 21-5.503B. Bill 64 expressly allows for beekeeping as a home occupation. The home occupation use is an accessory residential use, which is permitted in the agricultural, country, residential, apartment mixed use, business mixed use zoning districts. In the definition of beekeeping as an agricultural activity, I will be proposing a verbal amendment to amend the second sentence to read: the term does not include accessory commercial beekeeping in zoning districts where home occupations are permitted, which must comply with the standards for home occupations. The prior language specified the residential and apartment zoning districts, but home occupations are also permitted in the agricultural, country, apartment mixed use, business and business mixed use zoning districts. Beekeeping as a principal agricultural activity will be included in the outdoor animal raising use. The outdoor animal raising use is not subject to any standards. Note that Councilmember Wire proposed to include beekeeping as a separate principal use under the livestock and poultry keeping subcategory and permit beekeeping as a principal use in all zoning districts. However, permitting beekeeping as a principal, not an accessory use in the residential and apartment zoning districts may conflict with the purpose and intent of those zoning districts if the beekeeping use is the only principal use on a zoning lot. The intent of those zoning districts is to allow for a range of dwelling types and densities for residential purposes. Again, beekeeping can take place as an accessory use or home occupation in other zoning districts, including zoning districts where people reside. So as long as the beekeeping complies with other applicable laws, including animal nuisance requirements and home occupation standards. I'd like everyone to know that this approach to beekeeping maintains the current status quo in the existing land use ordinance. Under the existing land use ordinance, the minor livestock production use as a principal land use involves commercial small animal operations, including apiaries, which are places where bees are kept, and is not subject to any standards. In addition, under the existing land use ordinance, beekeeping as an accessory use is not regulated as a separate entry in the use table. Before I call up the administration, I would like to take public testimony, proceeding first with in-person testimony in the council chamber. Clerks, do we have any in-person testifiers for this item?
Chair, yes, we do.
Thank you so much. The first testifier we have is Austin Salcedo.
Aloha, Councilwoman Kiaina. Just to address these areas of concern, although it may not be agreeable to our Councilwoman Andrew Tupola, but some of these languages is made inside is of legal form, and the west side where we live is totally different of the Kailua area. We have been living on a self-sustainable type of cultural type of living. I'm here in behalf of my sons who are working, where I have the time to present these issues because I've been teaching them to my grandchildren of self-sustainability. And this, the setback on the agricultural lots for raising animals is 100 feet on abutting to the neighbor's property. That's not feasible and unachievable. I have a 1 acre property, setback of 100 feet, where my property's width is 130 feet. That's not feasible. So the language in itself doesn't fit my needs of my cultural type of way of living. And furthermore, I protest and object as its entirety to both agriculture and I've seen in this Bill 64 of group living as well too. I perceive that the language is made in a legal form only suggests and promotes gentrification for our district west side community. Bill 64 would only benefit developers and large landowners and benefit commercial bed and breakfast venues to rezone, dividing agricultural land into smaller portions, condominium property regime, CPRs. To create a legal form to segregate, discriminate against a rid of lower income people like ourselves and set income long-time community members within the District 8. So it may be good for the folks outside of the island, but on the west side, we have a different living culture. So I protest and object to Bill 64 in its entirety.
Actually, thank you. And I have, we have several staff that are counseling me, and so I'll take that into consideration. And I just want to let you know, while I live in Kailua, my family's from the west side.
Wonderful.
Yes, so I just want to let you know.
I know your office is spearheading this. Come to our neighborhood board for more clarifications. We do need answers to our questions, and our Andrew Tupola is overwhelmed with the violence in our district.
Good.
I support it entirely with the town hall against crime.
Thank you so much. Members, any questions? Moving to our next testifier, Kalei Salcedo.
Aloha, I'm Kalei Salcedo. From generation to generation, from my grandparents to this day, I have been teaching my grandchildren how to be self-sustainable. I know how the negative impact that this can be because we had lo'i farms on Kailua side. We had a millionaire that came on Kailua side, Hauula side, by the mountain side. The water got restricted. That squeezed our family out. To this day, before then, when I was young, we could feed half of the island of Oahu, Ulu, Kalo. We can't do that because of gentrification. They got the money, they're coming in, but you gotta remember, do not restrict me and my grandchildren, who's the future generation, to be self-sustainable. Because every time when something happened on the west side, we're the last one to get service. Inikiwi was the last one to get service. And I'm asking you folks, before you have any more gentrification up on the west side, the negative impact in our rights, my Hawaiian rights, to be self-sustainable, to take care of animals, to pick up my chicken eggs every day. And if we can't do that, that is going to be taken away. Who's going to give me a signed check so I can go to buy? I don't want to always have to buy things that in plastic wrap. We was raised to take care of our own animals, to raise them, to kill them. I'm not asking you folks or we're going to bag you votes because you know the culture. Do not eliminate, do not segregate, do not allow gentrification to continue pulling the west side. You ain't got that much country, and we got the highest agricultural land. Please.
Thank you so much for your testimony. Members, any questions? Moving to Earl Yamamoto.
Morning, Chair, Vice Chair, and members of the committee. Earl Yamamoto, State Department of Agriculture, here to testify. We stand on our written testimony, offering many comments, 14 pages long. The main points I'd like to highlight quickly. First, agritourism. On page 106 of EK7, agritourism should be replaced with accessory agricultural uses within the purpose and intent of the agricultural district. This is an important part of the LUO. And the reason we're asking for that replacement is that agritourism is not the only accessory activity to agricultural production that is acceptable. Going on the definition of agricultural, the definition of farm dwelling on page 200 refers to the principal agricultural use, which comes from section 205, 4.5 in the Hawaii Revised Statutes. That section defines agricultural education programs. The statutory reference should be the proposed statutory reference should be reassessed. We support the standards for farm dwelling as found in EK 7 on page 18 that includes the 51% of the zoning lot on which the farm dwelling is located that should be an agricultural use and dedicated as such. We have strong concerns about Chair Kiaina's proposed amendment made on September 20th, item 14 to regarding farm dwelling standards to delete that 51% requirement and the agricultural dedication status for as long as the farm dwelling use continues. Without these requirements, there's no objective measure of farm dwellings being accessory to an agricultural activity. This can have the effect of exacerbating ongoing subdivision of agricultural land, which is at the heart of the difficulties faced by agricultural operators seeking to access agricultural land.
Mr. Yamamoto, regrettably, since you signed up for the public testimony,
yes.
I need to limit you. But having said that, I guess I would like, because the State Department of Agriculture is clearly a major partner here, if I could have his testimony given to all of the council members, and during the Q&A with the Department of Planning and Permitting, any council member could ask you questions on your testimony. Is that okay?
Yes.
Okay, thank you so much.
You're welcome.
If you don't mind, members, I would, instead of taking questions now for Mr. Yamamoto, I will allow for you to ask him questions at the same time that we are able to ask questions to the administration. The next testifier is Micah Munikata.
Good morning, Chair, Vice Chair, members of the committee. Micah Munikata here on behalf of Ulupono Initiative. Testifying with comments, you have our written submitted testimony. It is still very lengthy. Appreciate all the work that's gone into this particular measure, specifically around the agricultural uses. There's been a lot of things that have been moving and very important for a lot of the producers that are out there. I think what we're trying to do, again, just to reiterate what we've said in previous hearings, is to promote agricultural production on our agricultural lands. It should be the largest priority when it comes to talking about our ag lands, is to make sure that we have room for our farmers and our ranchers to produce. We have many different goals, you know, to meet when it comes to our state. And land use really helps to dictate how we meet those goals. Everybody's seeking the same type of land. At the end of the day, ag was the default when it comes to district and zoning. And what we're finding now is, as some of the other testifiers just mentioned, I mean, the urban sprawl is real. And everyone's coming into our agricultural land. So we really need to ensure that if we are truly backing agricultural production, that we do it in a smart way. We look forward. We provide different standards within our land use ordinance that identify that a simple majority of 51% of your agricultural land that's suitable for production is in production. I think that that's a very key point that we should make sure that we maintain within our LUO looking forward. Again, Chair, we really appreciate working with you and with other offices, Councilmember Tupola and Councilmember Wire. I mean, it's been really great to have this open dialogue, and we look forward to supporting you in any way as we move forward.
Thank you so much. Members, any questions for Micah? Moving to Brian Miyamoto.
Aloha, Chair, Vice Chair, members of the committee. I'm Brian Miyamoto, Executive Director with the Hawaii Farm Bureau. Thank you for allowing me to testify. As previously testified, our testimony is pretty much the same. But we do want to start off and again thank the council, the committee, the members for all their hard work in trying to update LU and taking stakeholder input to ultimately come up with good land use policy that supports agriculture. We're very optimistic. There's so much attention on agriculture. Also want to recognize DPP and our State Department of Agriculture, and finally, all of the stakeholders for their input. This has been a long journey, and the Farm Bureau, we can see the light at the end of the tunnel, so we're thrilled. You heard the previous testifier. Our position has always been agricultural land, the primary use and activity needs to be agricultural production. 51%, which is being considered, is the minimum. That's not a lot to ask. Again, we appreciate the council considering 51% of farmable land and understanding that the entire parcel is not available for agriculture. Again, we just want to highlight a couple of things in our testimony as we did previously. One is East County Farm Bureau. That's new testimony that we included in the Hawaii Farm Bureau's testimony, but East County Farm Bureau will be available, and we support their proposed amendments. But again, our general recommendations, okay, that we would like to consider. Reactivate the Agricultural Task Force. Farm Bureau is committed to serve on that task force if that is the desire of the council. Also, we understand the budgetary constraints, but we believe that a position within DPP that has agricultural background will go a long way in future considerations for not just land use, but agricultural policy here at the city and county of Honolulu. Again, you have a written testimony. We will be available for any questions if there's questions for the Hawaii Farm Bureau. Thank you for the opportunity.
Thank you so much. Members, any questions? If not, moving to the next testifier, Jason Morgan.
Aloha mai kako. Mahalo, Chair Kia'aina, Vice Chair Cordero, members of the Planning and Economic Committee. My name is Jason Morgan. I'm a 7th generation steward of Kualoa Ranch. Kualoa Ranch has always sought to be a model of pono stewardship of our natural resources. Over generations, we've developed an operation that blends diversified agriculture, education, stewardship, tours, and activities, ultimately enabling us to be a positive member of the community as an employer of over 470 employees, a source of locally grown produce and protein for the community, and a destination for both Kama'aina families and visitors who seek to learn about and experience the many incredible aspects of what make Kualoa and Hawaii in general the amazing place that it is. Our operation has become sustainable because of the synthesis of these various efforts. Our tours and activities showcase and educate guests on our agriculture and stewardship efforts, and in turn, the revenue from these tours enables the continued investment into these agriculture and stewardship efforts. Last year alone, we produced over 137,000 pounds of food, all consumed here locally, had nearly 2,800 native species outplantings, and served over 10,000 local school children with our education programs. This was made possible by that economic sustainability that these tours and activities afford us. We remain concerned that the potential negative consequences of trying to create a one-size-fits-all process and respectfully request that the committee consider retaining DPP's ability to make case-by-case considerations on agritourism ventures that the LUC already affords so that legitimate community-supporting operations like ours are not negatively impacted. Mahalo and aloha.
Thank you. Members, any questions? Thank you so much. Moving
Mr.
on
Chair.
to Councilmember Wire.
Yeah, just a quick question. Yeah. Correct. Mahalo for coming down.
Thank you.
Just I want to make sure I'm understanding so we can make sure that we have it in our proposed amendments. So it sounds like there's potential concern that maybe certain activities could be construed as non-conforming with the changes that are made.
Correct. Yeah.
Okay.
From what I understand, either in the bill as written or in some of the proposed amendments, that it removes a pathway that the DPP already affords through that case-by-case kind of evaluation and discussion basis.
Okay. Do you think is there more specificity on the actual activities we could dive through maybe offline to better understand like the impact?
Sure. No, I'd be happy to, offline or whenever.
Because similar to that, well, I mean, if you want to share some now, that'd be great too. But I think that's a part of the concern we've had. Coming back to what was discussed earlier too, just about the 51%. I mean, I think it's a great standard. Many in our community would want it to be upwards of like 80% ag use. But I'd say in that particular situation, another concern that comes up is, say, kupuna that are maybe have a small garden on their land becomes non-conforming, then there's challenges if they need to like rebuild or, we're not trying to force anyone off their land. And I think there's similarities in the sense of activities going on that benefit the community. We just want to make sure it doesn't have unintended consequences. If there's anything that comes to mind now, I mean, feel free to provide specificity, but we can also talk offline.
Sure. No, I thank you for those comments. I think it goes back to, the one-size-fits-all approach is challenging in general, right? Because Kualoa Ranch is very different from somebody who is doing something in their backyard. And for us, we've ranched, we've farmed for generations. Those operate under razor-thin margins. When I was born, I think we had 7 employees. Now we're able to, gainfully employ over 470 employees. And again, that's through the synthesis of various, operations. We love to showcase and share, farming and stewardship with the folks that come to Kualoa Ranch. And it, ensures that they're involved in the future of Hawaii as well. The money that they are spending to come here goes back into the preservation of the place. It goes into that food production. And so for us, it's really that blend of all these things together that has, provided a model. It's not the model, but a model that again provides that economic sustainability and really enables us to care for the land in the way that it should be cared for. We continue to double down, triple down on expanding stewardship efforts, on expanding our ag lands and our grazing lands for our cattle. And again, this is because of the synthesis of the different experiences that we're able to share with folks that come to Kualoa Ranch.
Appreciate that. Thank you.
Okay.
Thank you,
Chair.
Councilmember Wire, you could also pose that to DPP. Thank you for your testimony. I actually felt that I tried to provide the greatest flexibility. A lot of people would have wanted parameters on the events, and we did not do that. We delegated that to DPP to be able to do that. So thank you for sharing your concerns.
Yeah, very much appreciated. Thank you.
The next testifier is Tom Holoak.
Aloha, Chair Kia Aina, council members Tupola and Wire. Thank you for your hard work on this. I'm talking about the relationship between animal rescue and agriculture. On Oahu, animal rescue takes many forms and much dedication. Today, I'll use the phrase put out to pasture as a good thing, meaning a place where animals can live out their lives being fed, cared for, and loved. On the North Shore, we have the first stables to take aging horses. In Kahului, a sanctuary for pigs, goats, cows, cats, and a turkey. Now, in the past, Oahu zoning regulations have not fully defined such unique places, or even what the words animal shelter actually mean. In fact, there is a temporal difference between an animal shelter and a sanctuary. Sadly, shelters often struggle with a ticking countdown to euthanasia, but sanctuaries are forever. Bill 64 is getting closer, but there's a major error that you're introducing that we object to and we believe it can be modified now. Please understand, in our work, we're not raising animals for sale or boarding them for clients. We are not breeding domesticated pets. In fact, we're pretty much doing exactly the opposite of that. We're saving dogs from illegal fights and domestic tragedies and feral cats from our beaches and streets where they're being shot with guns and arrows. We're actually very active wildlife conservation HOWAIʻI, helping to preserve our precious native forests and shorebirds and monk seals from damage which free-roaming cats might cause their ecosystems. Now, some folks are even rehoming old but expensive to maintain horses. We help them all at absolutely no cost to the taxpayers, so you can help us today. Here's what we
Tom,
need.
you're going to have to wrap up your testimony, please.
Okay, we belong in the table animal raising outdoor. Councilman Wire, you've shown the way with your item 8. The second sentence reads, the term livestock includes cattle, horses, goats, sheep, swine, dogs, and rabbits that are not raised as household pets for purposes of personal use and companionship. You just need to add the word cats in there. We are not holding these animals for personal use and companionship. Now, if you include the term, Chair, the term does not include animal shelters, see animal care, that's a very serious error because if you do go to see animal care, you will find that suddenly animal shelters will fall on table 21-51 under parking lots. Personal services, animal care, minor.
Please wrap up, sir.
Okay, so we do not function as a personal service. For now, we need the wording in Bill 64 to be more pono. We save animals. We do not belong in the commercial category. We belong in the agricultural category, we think. And Councilman Wire, you know about what we're trying to do. Thank you for all your assistance, and thank you.
Members, are there any questions?
Chair. No question, but just a comment. I just wanted to say that I understand what you're saying, and I think when we talked about animal care in commercial, it was about like veterinarians and, you know, buildings that have aircon, because requiring that for outdoor kennels and stuff is just like not going to happen.
Yes.
I hear what you're saying, so
Yeah.
I hope we have this discussion because I think I stand in the same place that there is not only animal care inside a air-conditioned building. Thank you.
Thank you.
Thank you, Chair.
Thanks so much. Exactly. You got it perfectly.
Thank you. The next testifier, Holly Holowak.
Aloha. Oh, aloha kako, Chair, council people.
Can you bring the mic closer?
Sure, I'm sorry. I just wanted to hold up our vision board while I'm talking so you can see it. Okay, my name is Holly Holowak, and I'm the founder of Popoki Place, Oahu Cat Sanctuary. We have a lot of support in the community. Everyone is waiting for us to build the sanctuary so we can do the good work that we are planning to do. Remove feral cats from the beaches, parks, and areas where endangered wildlife, and keep everyone safe. But we can't start until we get land. We just need 5 to 10 acres. We have looked at hundreds of parcels of land in the entire island for the past 3 years. Why haven't we secured it until now? Zoning. Let me ask you guys a question. Here's our plans. I'll tell you a little bit about what we want to do, and then you can answer. We need several acres of pasture land because we plan to house hundreds of cats in large outdoor, securely fenced enclosures like in the drawing, similar to a large zoo, in a beautiful park-like setting. We will be open to visitors and the island around the state. We'll be open focusing on education to explain to the visitors about our fragile ecosystem and how to protect the native wildlife, especially endangered birds and monk seals. We will be a community asset. We are not a shelter or kennel. We are a sanctuary, like those for farm animals or horses that are being rescued. We are a nonprofit organization. We will be a pressure relief valve for shelters like the Hawaiian Humane Society and others who want to save animals but don't have the room. We have no intention to ask for important agricultural lands, which is needed for food. Although throughout history, cats have always been farm animals as barn cats. So what I want to ask is, where do you see us fitting into the LUO list? You have an opportunity right now to make it possible for us to secure land simply by adding the word cats to your list of eligible items. In item 10, Councilman Wyer's suggestions.
Please wrap up.
He says, the term animal raising includes cattle, horses, goats, sheep, swine, dogs, and rabbits. Please, we are asking you to add cats to that list. Mahalo for your time and consideration. I have some brochures for any of you who would like to learn a little more about our program, and you can go to popokiplace.org. Mahalo nui.
Members, any questions?
Would you like that?
If not, we're going to move down to the next testifier, Sundance. Go here.
How's it? My name's Sundance. I share similar problems like this brother and sister over here on the west side, but I'm on the east side. Being, I feel like a lot of these bills that I'm standing here for is kind of written probably because of my family back in the past on the setbacks and the zonings. I grew up on chicken farms and pig farms where my uncles had to quit because they developed residential lands near my family's lands, and they turned it to residential where got pushed back to smell pollution or noise pollution. For example, I was watching the last one and I seen Mrs. Tupuola mentioned something about being grandfathered in. In the past 10 years, I've been able to purchase an acre of property back on the east side near where I grew up on my family's lands. So I just got back into farming just for therapy and all that, but now with the cost of living and the union I'm in suffered 2 strikes in this past year and a half, and I got opportunity and potential to utilize 100% of my farm, where I'm kind of mad because you guys telling me I got to use 51%, but I got to beg for 100%. If you guys can understand what I'm saying. On the zonings, yeah, back to my uncles, they were grandfathered in back in the days. But what happened to them, when a new neighbor come in, they had a head count. Somebody came with a head count. Okay, Mr. So-and-so, you can only raise this amount of pigs and roosters, per the farmland. Then when a new neighbor came in, they watched them. Then when we get hurricanes or bad weather, we lose stock. Then they would call the cops, Humane Society. Then they would come in and make a recount, like out of nowhere. It's like, hey, first you guys told me I'm grandfathered into this amount of number. Then throughout over time, the numbers disintegrated. And I'm wondering if you guys still got that type of grandfathering in that can affect me. So you guys come to me, I'm legally, with the amount of raise, how I raise, I'm fine with my neighborhood right now. So you guys can come grandfather me legally, but now throughout over time, you know how hard it is for a farmer to raise this exact head count? Just Mother Nature alone can take me out throughout the years. And you guys can come anytime and tell me, oh, now I'm only down to this much. And then what I'm grumbling to is to be able to use my whole 100%. I got to find ways, I can rent out to, I got friends raise sheep, chickens, and all that. I got to go to my property boundary.
Sundance?
Yes.
Can I clarify a couple of things? Are you, whose district do you live in?
On the Kalailea, on the Winter Kalu side.
Oh, okay. So that's likely Councilmember Wyer's
equivalent
district.
to like West Side. We got a lot of farmers there.
Okay, so can you clarify, because I'm going to have to move on to the next testifier, clarify, are you thinking that because of the percentage, you're not able to utilize 100%?
Yeah, I would like to because, had noise pollution. I have an uncle like 2 streets down.
100% agriculture, right?
Yeah, I want to be 100%.
Nothing is going to impede you from using 100%. When we put percentages.
No, but if a neighbor complains, because that's what happened to my uncle.
Got it.
Like a new neighbor. Right now, I'm good with my neighbors. They've been there for decades. But if a new neighbor come, he has the right.
Similar to the previous testimony, the first testifiers with regard to setbacks. Thank you for clarifying.
Yes.
And for being here today.
Thank you.
And if you need further follow-up, your council member is Councilmember Wyer.
Who?
Councilmember Wyer.
Thank you. Oh, okay. Yeah,
okay. The next testifier is Mike Pesh.
Aloha, council members, chair. Mike Peach here with Title Guarantee. Thanks for letting me testify on behalf of the bill and the ag rules. I just want to point out, and some of the testifiers pointed it out also, that all the ag lands aren't actually similar. The ag sizes are so different, especially in Ag 2. You could have a parcel that's 500 acres. You could have a parcel that's half an acre. We've got about 2,200 properties in our ag district on the island. And of that, 700 of them are less than 2 acres. So I think as we're implementing restrictions, those restrictions adversely affect those lots in different ways based on the sizes. When you're talking about a lot that's an acre or half an acre, which could be a bunch of Kuleana lots, they have an inherent right to live on the property. They have a right to a farm dwelling. But when they end up getting a septic permit, that septic leach field could be roughly 30,000 square feet. That could take up over half their parcel by far, and then you have your house on there. So they couldn't necessarily comply to that 51% on a really small parcel. In turn, maybe they can't get a building permit and they couldn't live on their parcel. So I just recommend maybe we dive in further into understanding the 2,200 parcels and how these rules adversely affect each parcel depending on size.
Thank you so much. Members, any questions? The next testifier is Catherine Metzger.
Good morning, Council Chair and members. My name is Katie Metzger, and I'm the founder of Hanai Hives. Nice to see you all again. Appreciate the opportunity to come back. I have a bee farm with 4 apiaries on the North Shore. Currently, we work with 42 families who have Hanai hives from us, and our mission statement is to raise healthy bees and grow mindful beekeepers. The way Bill 64 pretty much rocked our world, and for lack of a better word. And so we really appreciate you taking, I'm really here, honestly, to mahalo you for taking the beekeeping community's feedback and amending the amendments that you proposed, specifically Matt Weyer and Esther K. Aina. And also, mahalo you in advance for your continued conversation and willingness to answer our questions, because I'm just sitting here in the back of the room, I'm realizing definitions matter. And I appreciate all the amendments. They seem to be aligned with what we were asking for, but there's some wording that I'm concerned about the language. This bill may outlive me. And so I have a responsibility to the beekeepers I'm working with now, but also future bees and beekeepers on the island. So yes, mahalo again for your continued willingness to work with us till this is actually passed into law.
Catherine, thank you so much for your testimony. And to all of the beekeepers, I need to give all of you a gold star for effective advocacy. I feel that the beekeepers have been the most ardent advocates through this process, and I think that was to surprise to many, and it could have been because of the proposals that were originally proposed by the Department of Planning and Permitting. And I know that you would appreciate this story. Last week, Thursday, while I was finalizing the amendments, I had 2 attorneys who were counseling me for nearly an hour with differing views on bee strategy, and I was almost getting whiplash because of the constant tit for tat. So I wanted to let you know that we did take all of your comments into consideration. I know that you've met with some of the staff, and we felt that we struck the right balance, given the complexity of the issue. And of course, if there are any other things that you guys are interested in, just please let us know. So thank you for being here today. Clerks, are there any other in-person testifiers?
Chair, there are no other registered testifiers.
Is there anyone else standing by in the chambers who would like to testify in person? please come up and identify yourselves.
Can you hear me? Okay. Good morning, and thank you. In consideration of time, I'm just going to try to run through these quickly. With regard to the
If you could
agritourism.
identify yourself, please.
I'm sorry, Raquel Achu, North Shore. Basically, in agritourism, tourism obviously has impacted our lands pretty significantly. Any activity that is added to ag land use and has no nexus to the primary ag operation should go through a strenuous, detailed process such as the CUP major. However, there are existing and established ranches and farms that already hold a CUP minor and should be honored or grandfathered, however we can not impact them negatively as they've already been operating. I've commented in the past, it is critical that in this process we don't make compliance or operation more difficult or suffer negative impact for the established ranches or farms. With livestock, I just wanted to note in animal care or wherever it's stick, I didn't see it, but farriers, they shoe horses, they have not been included in a lot of that conversation. I appreciate Councilmember Wire for adding dogs. You might want to add just working dogs. That would be addressing the herding working dogs. And horse boarding, obviously, I think is a given, just not sure. In terms of dwelling, I'm hoping to address yurts. Although I know they're not legal anyway, they are popping up on a lot of our ag lands and have no real, they're not addressed or recognized. Farm dwellings, being that they are accessories to the ag land and not someone's dream mansion, it's an accessory. It should be noted as an accessory to the principal use and primary land owner or operator. And hopefully, because we have Ag 1 and Ag 2, Ag 1 being 1 dwelling per 5 acres, 1 dwelling per 2 acres in Ag 2, are we able to identify a cap? Because obviously if you buy 100 acres and you're Ag 1, are you allowing them 20 homes? Because that now impacts the footprint of our community, and it impacts resources, traffic, and all of the things, environment, the things that should be addressed in that permitting process. In the farm worker housing, I'm curious to know if they have more than two or three.
If you could summarize your comments, please.
Okay, 2 or 3 units, does that prompt additional permitting review? Because again, that's just a hidden development in my opinion. And then in the use, agricultural use for the ATVs and motorized, if we could add the word recreation to amusement and entertainment. Thank you.
Thank you so much. On the dog front, we did catch that, so we are gonna clarify.
Thank you.
Councilmember Wire.
Quick question. I'll ask DPP about to flesh out the cat or the number on units, right, if you have 100 acres. I just wanted to get more input because I know the community's been going back and forth. I understand there may be differences on the minor major for agritourism. Just wanted to ask if the distinction in the proposed amendments addresses those existing uses, or we need to flesh that out anymore in terms of not slipping anyone or pushing anyone out of the minor into the major.
Right. I think because we do have ranches and farmers that have motorized vehicles, ATVs, whatnot, I think addressing the recreation, entertainment, amusement part helps and is specific. But if they've already obtained a permit, they should be able to honor that and not be driven to move to have to get a major.
Okay. And just to clarify, that's the use of the motorized in the activities versus for the purposes
right.
of recreation.
Right.
But more to perform the work Is
Right.
that fair? Or?
Yeah, I mean, it already states for working ranches, which is great. But if someone, like, for example, Kualoa, they have their extra, that's great. They go through their permitting process. They've done it all already. So do we go back now and impose a major on them if this goes through a CUP major? Because they've already gone through their permitting process. And technically, the space that they use, it doesn't even exceed 1% of their total acreage. So, you know what I'm saying? Like, I don't want to say, like, if this happens, do we go to these people and say, oh, now you got to get a major? A major CUP would really, really impact a working farm and ranch if they're trying to do something to supplement their income.
Appreciate the insight.
Mhm.
Thank you, Chair.
Chair.
Yes, Councilmember Tupola.
Thank you, Chair. Thank you, Ms. Achu, for being here, and I also think you deserve a gold star. You've been keeping up with all of this. I'm going to double down on what Councilmember Wire said just for clarification, because I did submit that, and specifically when we worked in our working group, we wrote that these motorized vehicles, ATVs, all of these things do not interfere with farm and ranch operations, which is written in there, but we also said, and are not for entertainment and amusement purposes, which is the thing we're trying to avoid.
Yes.
So specifically in line 11 on the chair's draft, like, we really need to talk about the conditional major that requires a lawyer, that requires tons of money, that is going to be hard for farm operations. So that little sticking point is what I'd like us to discuss when the time is right. But thank you, Ms. Achu.
Thank you.
Thank you. Anyone else in the room who would like to testify in person? Please come to the podium and identify yourself. And I just want to remind everyone that you have a minute.
Thank you, Chair Casey Alexander. I'm Vice Chair of the North Shore Neighborhood Board Agriculture Committee. With Ms. Achu, we did submit formal testimony, but I'm speaking on my personal behalf today. I did register. I think I'm listed as one of the online people. My written testimony includes specific recommendations on language that are based on 4 principles that I wanted to highlight today that I would urge the Council to consider in reviewing use of the land use ordinance related to agricultural uses. 1, as has been stated, the importance of creating a regulatory environment that fosters and promotes agricultural production as the #1 consideration. 2, the importance of supporting small and micro farms and homesteads based on the critical role that they also play in reducing Hawaii's reliance on food imports, increasing our food security. A return to the large-scale monocrop commercial agricultural operations is both not likely as well as not desirable, and so we need to support our small farmers. 3, the importance of allowing farmers to live on the land in order to protect their crops, livestock, and equipment from theft, and to enable more affordable and sustainable farming operations. And 4, the importance of regulating for the activities that we want to support, as opposed to regulating against small instances of potentially bad actors. I have 4 key concerns outstanding. I'm happy to follow up with Councilmember Wire as there is time.
Thank you so much. Members, any questions? Anyone else in the room who would like to testify, please come to the podium, state your name. I'm sorry, thank you.
Hello, yes, my name is Max Towie. I'm a beekeeper, and I'd like to thank you for all of your hard work to hear us and take care of us, especially Tupola, Wire, and Esther. Thank you so much for your amendments. Thank you for putting it all together in such a no-fuss way. You know, it was really terrifying seeing that original draft, and I mean, oh man. But thank you so much. I really appreciate everything that you folks have done for us. And thank you to DDP for everyone who answered my questions and da-da-da-da-da.
Thank you so much for your testimony. Just know that we value your role, beekeeper's role in agriculture.
Aloha kako, I'm Chrissy Kohine. My roots are in Maili Waianae, and I'm here to just emphasize and echo what my fellow friends and community members have talked about in terms of potential negative impact. So really, when we talk about potential for loss of agricultural land when it comes to development, I hope that we all have kept in mind as part of the discussion that once it's lost to development, there's no way to replace that. It is irreplaceable. I come from a generation of farmers. My grandfather and grandmother, who I still live on the property, so I have agricultural land which is being used for 100% agriculture. Pig and chicken farmers, but I have already experienced what the other gentleman from on the east side was saying. I had some pigs, it went over what my neighbors thought was a good limit, and so I actually had a lien on my property because of smell, because around me now there's development that's happening, and so I understand where this gentrification, this concern about our less space for us to raise our own food, right? Because now we're talking about food security, food sustainability. And if anybody is from the Waiʻanae side or you have Ohana there, you know that is one of our primary concerns, is really getting back to making sure that we're growing our own food and that we have the ability to sustain ourselves. And consider the environmental impact and of course our Native Hawaiian culture. Think back historically, the reason why our side of the island has the most amount of agricultural land, the government actually pushed it out our way. So please don't take that away from us now. Aloha, mahalo for your time.
Thank you so much. Any other testifier in person? I'm going to move to remote testimony. Clerks, do we have any remote testifiers for this item?
Chair, yes, we do.
We have Frederick Mencher. Frederick, are you online?
Yes, I am.
Please proceed.
Okay, thank you. Fred Mencher, I'm representing the East Oahu County Farm Bureau. One thing we would like to recommend is that Bill 64's use table be modified to include urban agriculture and aquaculture as permitted uses within the industrial zones. With 90% of Honolulu's food supply coming from overseas, we shouldn't rule out any viable sites for increasing local food production. Aquaculture, aquaponics, and hydroponics do not need to be done in an open field. They're often done in enclosed facilities that allow intensive production, make efficient use of water and nutrients, protect crops from pests and diseases, and produce minimal waste. Aqua farms have, in fact, been located in Campbell Industrial Park, where the necessary resources of water, sunlight, and electricity are present. The state is presently considering a site at Campbell for a proposed aquaculture park. So we respectfully request that urban agriculture and aquaculture be listed as permitted uses in the industrial zones. Thank you very much for considering this request.
Thank you, Frederick. We did, so that would be under industrial uses. We've completed that, but at the end of this hearing, I am going to outline the timeline for the rest of the consideration of Bill 64. So your recommendations are duly noted. So thank you for testifying. The next testifier is Kim Falinsky. Kim, are you online?
I am online. Can you hear me?
Hey, aloha. Please proceed.
Aloha. Thank you very much for accepting my testimony, and apologies for not being able to be there in person this morning. Thank you for all of the same work you've done. I echo Max Toi and Katie Metzger's testimony. My name is Kim Falinsky. I am the owner of Nalomeli Honey, and I've been a beekeeper on Oahu since 2007. I appreciate that Council having made all of the changes to the amendments that have been discussed already and the time put into this bill. The small notes I would like to make in terms of these amendments, Councilmember Kia'aina, I heard your verbal amendments this morning, and I think I understand them about the importance of defining what zoning is underneath home occupation. So in keeping with the idea that beekeeping is a primary agricultural use, the new amendments really address that well. But for home occupation, I just want to make sure that our testimony includes the idea that for home occupation, there's many, many different underlining zonings that would be okay for having beekeeping and would make it both an urban and an agricultural use in its full form. Thank you for supporting beekeeping in all of its forms and keeping this as a business opportunity for future generations that doesn't need a lot of water or land. Thank you very much.
Thank you so much, Kim. I believe I clarified that home occupation could be on other.
I was trying so hard to understand. It's quite confusing, but thank you for looking into it.
But I know that you guys have been in contact with Brianne Nuuhiva of my staff, so if you need any clarification, you could contact her. Thank you so much. The next testifier is Steve Montgomery. Is Steve Montgomery online?
Testifier is not logged on.
I haven't seen Steve in a long time. So anybody out there, tell Steve that Esther Kiaina said how come he wasn't online, okay? The next testifier is Taylor Campbell. Taylor, are you online?
Yes, I am.
Hi, Taylor. Please proceed.
Aloha, my name is Taylor Pi'ike Campbell, and I'm here on behalf of WA'a, the Waimanalo Agricultural Association. I sit on the board, and I'm also a second-generation farmer from Waimanalo. WA'a has been involved in the evolution of Bill 64 since its inception when it was still under Bill 10, and have been actively working with other farm entities on recommendations for the committee's consideration. We've included written comments, but would like to highlight 4 important requests. First is prohibit schools on Ag 1 and Ag 2 and country-zoned lands. Normal agricultural activities like spraying, animal odors, machinery noises, and so on generate complaints from these organizations, which hinders our daily operations. The Hawaii state constitution preserves the right to farm. Schools located too close to true agriculture may impede on these protected farm activities. Second, reactivate the Agriculture Task Force and Agriculture Liaison to meet regularly for essential discussions. Third, add a position within the Department of Planning and Permitting that requires a background in agriculture. Without a position, it's difficult for DPP to make land use changes that support Oahu's agricultural production. And 4, if agriculturalists are faced with adverse impacts on farm operations because of the final version of Bill 64, we ask that you may grant allowances and grandfather them in. Like I said, we've submitted written comments reiterating these stances with additional recommendations. Thank you for your time and consideration.
Thank you so much for your testimony. Just so you know, Councilmember Chipola and I have introduced a resolution yesterday, and we will be having a hearing on reconvening the Agricultural Task Force on October 22nd. And I also wanted to mahalo the association for your work with DLNR, DOA, and OISC with regard to addressing the coqui frog infestation that has long been in Waimanalo, and all of a sudden we're getting media attention because they want to jump over to Kuli'o'o. So I'm hoping that we get the attention of Chair Waters as well, so that he could help fight with us to make sure that we take care of the coqui frog. Thank you for your testimony. The next testifier is Sandra Van.
Chair, testifier is not logged on.
Next testifier is Karen O'Mahony. Karen, are you online?
I am. Thanks so much for the opportunity to testify.
Please proceed.
We have country zoning, and I just want to make sure that we aren't negatively impacted as has been indicated by this bill. So in addition to diversified agriculture and livestock and farm and animal education and a horse program, we are also a community, a land that benefits the community, and not just our farm programs, but we also have 15 families that live on our zoning. And if you guys make this so I cannot have the livestock and I cannot have the other things, then we'll just have to sell the development to the land to the developers who are waiting to buy it before we were. These 15 families will be out of housing and we'll lose more agriculture. Even though I'm not Kualoa Ranch and I don't produce tens of thousands of pounds of food and I don't have 480 employees, we serve a very similar purpose in addition to the housing in the area. This Bill 64, and I'm grateful that you've made some amendments. The only time I feel like we were really able to be heard was at Andrea Chipola's workshops. This 1 minute thing is insane. I don't even know how to say anything in 1 minute, but doing my best. The restrictions on bees, livestock, the setbacks are completely impossible. Our property is 230 feet wide. If I can only use if I have to have a 100-foot setback, I can't use the land. So all of these things point to the fact that this has not been understood. One of your members just asked one of the testifiers a minute ago, oh, well, are we going to catch people up in the, is this going to hurt existing people? Yes, it is. And the fact that you guys don't know who you're going to hurt with all of these things is the problem. So I get it that it's huge. I know that you all work really hard. I'm sorry I don't have time to use my minute to thank you all, but this is too important, and there's too many people that are going to be negatively impacted by these restrictions. So please adopt Andrea Tupola's amendments at the very least. Thank you.
We've actually adopted several, but right now I'm still, for me, outstanding in my mind is I need to have a more robust discussion on the setbacks, but I think you may be uninformed about a lot of the amendments that we have made to address a lot of the concerns you've raised. Thank you so much.
And it's possible. I'm working. I don't have time to learn all of this, but we need to be able to trust that you guys are going to. And the man in Waianae who said he wouldn't be able to use 100% of his property, that is because of the setbacks. If you make setbacks that are ridiculous,
yes, I got it.
Then we cannot
he's actually
use 100%
in East
of our
Honolulu.
property.
Thank you, Karen.
I'm sorry. Please
is there anybody else standing by remotely to testify?
Chair, there's Chun James, and you missed Gil Riviere.
Oh, I'm sorry, Senator. Let's go with Gil Riviere. I'd like to appoint Councilmember Tupola to the committee so that we can have quorum.
Thank you.
Please proceed.
Okay, thanks. Thank you. I hope you get a chance to review. I have other comments, but I'm going to focus on 3 specific things in my testimony and one that I forgot to put in. I think it's essential that an accessory use, any application for an accessory use or agritourism, there has to be active agriculture before they make the application. I don't think that's an existing statute. I think it's outrageous that people come in and say they're going to plant or they're going to do something if they get a permit. I think that's backwards. Make them prove their agricultural activity first. Secondly, the term zoning lot sounds clear and concise. Determine that. Obviously, the director is ultimately responsible. There needs to be a clear process for that. And finally, the agriculture housing, the farm housing, would allow up to 50 acres of farm housing, but in the language, I don't see that it requires it to be reserved for agricultural farmers or farming workers. And in fact, it even says when the associated farm is no longer in active production or no longer employing farm workers, no workers may be housed on the zoning lot. Does that mean that everybody except farmers can be housed in the lot after the farm closes? Is that truly the case? Then we have a problem. I would suggest that anytime there's a large farm housing development, that maybe there be a 50-year commitment that it reserved for farm and agricultural housing for at least 50 years. Then we're going to see the sincerity of the agricultural enterprises. And I thank you for your time.
Thank you so much. Members, any questions? If not, we're going to move on to Chun James.
Hey, aloha. You are on to a really big monumental task, and I know it's not easy, to try to cover everybody across the board. But I just wanted again emphasize that there are more small farmers than there are big corporate farmers. And especially that farming is a chosen lifestyle. Just like our friends and our sisters and brothers from Waianae, they want to be able to just live a sustainable life where they can just go pick their eggs, whatever it is. I think that there are corporate farm owners and there are desktop farm owners, but seriously, the small farmers really ought to have a big say in this. And I also want to say that on mainland, nowadays, a lot of buyers who want to buy properties near farmland, they are told to sign a disclosure that say, hey, if you buy something near a farm, expect to have farm smell, expect to have noises and this and that. So there's still a lot to talk about, but I just want to emphasize that farmers, that we have more small farmers, and that it is a chosen lifestyle, and that hopefully there will not be so much restrictions and regulations that it is going to, become a really life of hardship for our small farmers who have chose to live sustainable life. Thank you very much.
Thank you. Thank you, Chun. I think we are endeavoring to tackle that issue because it's impacted in different parts. And later on, I'll talk about the farm stands, which Councilmember DePola has raised. And so I think we are endeavoring to try to help the small farmers. Members, if there's no other questions, I'm going to go to the next testifier. Good to see you again. The last 3 digits of the telephone number is 195. If you are online and you'd like to testify on Bill 64, could you please proceed? Again, the last 3 digits of the phone number is 195. Clerks, are there any else standing by remotely?
Chair, there are none.
Okay, members, we are going to go into discussion with the administration. We have Don Takeuchi Apuna, Director of the Department of Planning and Permitting. And as I earlier stated, we have Earl Yamamoto, Planner for the State Department of Agriculture, with over 40 years of experience in the agricultural industry. I have placed on your desk his proposed recommendations, and so you can feel free to ask either DPP or the Department of Agriculture any questions you might have. Councilmember Tupola.
Thank you, Chair. Aloha, Liz. Thank you for being here.
Oh, I'm sorry. I'm sorry. I'm sorry, Councilmember. I'm going to go through my questions and then we're going to go by category. Is that okay? Sorry, I forgot. It's been so long already. We're going on 2.5 hours already. So members, before I entertain questions by all of you, I would like to first focus our discussion on questions for the DPP by subject and then open it up to any other questions. I will ask questions in this use order: agricultural energy facility, agriculture farmers market, agritourism, beekeeping, biofuel processing facility, farm dwelling, farm stand, farm worker housing, and other. Members, my amendments to the agricultural uses and corresponding conforming amendments continue to update the use table, use standards and definitions to try to address concerns expressed by both industry groups and the public regarding the impacts of different uses and how to mitigate these impacts, and to clarify what type of activity each specific use includes and does not include. For today's discussion of agricultural uses in the accessory agricultural subcategory, please keep in mind that accessory agricultural uses are uses that are accessory to a principal agricultural activity occurring on the zoning lot. With regard to the agricultural energy facility use, I am recommending amendments to require a minor conditional use permit in the Ag 1 and Ag 2 zoning districts, which is meant to allow the DPP to address impacts of the agricultural energy facility use on a case-by-case basis if needed. My Council Communication 243-2024 proposed to amend the standards to clarify that a minimum of 90% of the activity on the portion of the zoning lot or zoning lots used by the agricultural energy facility must be crop production or livestock and poultry keeping, to track the language in HRS 205-4.5A17. I will be proposing a verbal amendment to amend this standard in ROH 21-5.40-4A1 for clarification purposes to read as follows. No more than 10% of the portion of the zoning lot or lots used for crop production or livestock and poultry keeping may be used for the agricultural energy facility, consistent with the regulation of permissible uses within agricultural districts pursuant to HRS 205-4.5A17. Amend these standards to add a 300-foot setback requirement from any adjoining property within the residential apartment or apartment mixed zoning district. This is to mitigate impacts to surrounding property where people live. as we will discuss a little later, the biofuel processing facility use as accessory to agricultural activity will be included in the agricultural energy facility use. For DPP, and then maybe why don't you, actually you could do it after. I'll ask the question. What is the DPP's position on including the biofuel processing facility use into the agricultural energy facility use, which is also an accessory agricultural use?
Thank you, Chair. Good morning. My name is Elizabeth Krieger for Department of Planning and Permitting. Good morning, Chair and committee members. It's been a very interesting discussion this morning, and thank you so much to all the testifiers and the council members for having such an enlightening discussion. The department supports the proposal to take the accessory biofuel processing and include it in the agricultural energy facility. We think that those two uses are consistent and there's no need to have two separate uses for that.
Members, do you have any questions for DPP about the agricultural energy facility use? Okay, we're moving on. With regard to the agricultural farmers market use, I'm recommending amendments to delete the requirement for adequate off-street parking and vehicular access because this can be addressed in the minor conditional use permit on a case-by-case basis if needed. It also clarifies the definition that the use is an accessory outdoor market for the sale of Hawaii-grown products located on a zoning lot with the principal agricultural use. This is to distinguish an agricultural farmers market from the more commercial farmers markets occurring in zoning districts other than the agricultural zoning districts. Actually, members, do you have any questions for DPP about the agricultural farmers market use?
Chair.
Councilmember Tupola.
I think you're on 917 for yours. I'm trying to follow along. Liz, my question real quick is about number 2. So number 1, 917, Councilmember Kaina's 1, says the hours. And then number 2, it says the 51%. And then in our meeting that we had, we talked about it, that obviously the 51% is for agritourism and other things. We're literally talking about a farmer's market here. So this is not in regards to the use of the land or whether or not it should be all ag or used. So like, my question is whether or not that's necessary, because I feel like that phrase was stuck all over the place in places it shouldn't be. Does that belong there for the farmer's market one?
Well, thank you for that question, Council Member. I think that is a policy determination. You're right that the farmer's market, the agricultural farmer's market is intended to be facilitating agricultural products. In terms of it being accessory, the question about how you would specify accessory, I think 51% has often been used as like a more than half being, if it's less than half, it's accessory. I think a lot of places use that as a relatively simple function, but in this case, I think that it would be supportable to have other ways of making it accessory. And again, that's a policy decision.
Yeah, I mean, my comment was just because I think we're already all under the understanding that it has to be over 51%, but we're talking about a farmer's market here and not the use of your whole entire piece of land. So just clarification. Thank you, Chair.
Okay, moving on to agritourism use. I'm recommending amendments to amend the standards to refer to accessory destination events, including weddings, instead of weddings and similar accessory destination events. This would better cover destination events other than weddings, for example, family reunions, anniversaries, or birthdays. My amendments also incorporate Councilmember Tupola's proposal to incorporate a reference to ranches, in addition to farms, in the agritourism use standards. These appear in portions of line item number 8 and line item number 9 of Councilmember Tupola's Council Communication 241, 2024. I will also be recommending the acceptance of Councilmember Wyer's proposal to separate the agritourism use into minor and major uses, with a minor conditional use permit required for the minor agritourism use and a major conditional use permit required for the major agritourism use. These appear in line item number 2, a portion of line item number 5, and line item number 7, as modified in my response communication to make technical revisions in Councilmember Wyer's Council Communication 240/2024. Councilmember Wyer, would you like to provide more detail on your proposed agritourism use amendments?
Thank you, Chair, and appreciate your indulgence. And I guess the distinction would be just to recognize that there's certain activities that are more in line and less impactful in the community and also are traditionally been going on in our community. And so the types of activities that we would classify as a minor use of the property for picnic grounds, greenways, hiking, bicycling trails, fishing, hunting, limited accessory sports courts and fields, non-motorized access to scenic interests, and horseback riding tours are things that we have going on in multiple locations in our district with minimal impact and accompanying generally larger agricultural activity, as agritourism is supposed to, right, as an accessory use. The major activities were just those that we were concerned, every other activity, so that we would be concerned that may have a greater impact, particularly what we're seeing now with motorized vehicle use of agricultural lands in a way that is degrading it and other types of activities.
Thank you. Do you have any questions for DPP or any other member here? Do you have questions with regard to my amendments?
Not a question. I may just make another comment that I'm open to receiving additional feedback from stakeholders on this particular one.
Okay,
this
thank you.
particular issue.
Councilmember Tupola.
Thank you, Chair. Yeah, thank you, Councilmember White. I agree with the minor-major delineation. I think his district has more of that than I do. Specifically in your recommendation, Chair, the two things that I disagreed with was listing the word including weddings, because accessory destination events is everything. And the wedding industry did attend quite a few of my workshops and specifically said that they didn't want to get like singled out like that. So whether or not it's included or not, no one's going to die, but they did make that mention. And I think accessory destination events is large enough of an umbrella to include them and every other thing, including reunions and baby parties. Secondly, and number 6, I do think that we specifically talked about this for a lot of time about that anybody using bus, Jeep, off-road vehicles, et cetera, that they should be required a conditional minor to be able to use it and not a major. And then, of course, my one recommendation was that we delineate the word not for recreation purposes. So those are the only two things. Everything else, I am grateful. Thank you for incorporating it. I think those two things are small changes.
Thank you. So no questions for DPP, right? And Councilmember, if you guys have, for the amendments, but, you can just make sure that we get it before the next hearing. On
Sure.
the 20, do you have any more?
Oh, I would just invite DPP to respond or provide any additional thoughts on the distinction.
Sure.
Yeah.
Sure, thank you.
Since we have them here, so appreciate it.
Yes, I actually think that that's a really good idea to have a major-minor distinction that allows us to offer a shorter timeline for those uses that are trying to be, say, have a creative agritourism idea that doesn't take big changes to their lot, if they're doing hiking, horseback riding when they already have horses, that kind of thing. The minor conditional use permit is a 45-day permit, whereas the major conditional use permit is a 90-day permit, and before the conditional use permit major, they need to present to the neighborhood board, and the Department of Planning and Permitting holds a public hearing. So those are the two key differences between the minor and the major process. Both of them have to evaluate or the department has to evaluate the proposed use against the goals and criteria for issuance of a conditional use permit. So it's not like we maybe do a lighter analysis. We still do an analysis to ensure that any impacts are mitigated and also to ensure that the principal agricultural use is a legitimate bona fide agricultural use.
Okay, thank you.
Chair, can I ask a follow-up?
Sure.
For the two suggestions I gave, what is you guys' position? So do you believe that there needs to be a conditional major for the use of these off-terrain vehicles for ranches and farms?
That's a good question. I think that is also a policy question. I think for the types of agritourism, or, you know, we don't call it agritourism right now, we call it agribusiness. There are only a handful that are proposing this kind of get on an ATV and drive around. So I think the question of whether that is similar to horseback riding, if it is, because they're just going to maybe go on existing paths, then that would be appropriate to be included in the minor. Whereas if we think that that would generate a lot of dust and would be, you know, would probably include paved roads otherwise or something like that, then I could see that being major. I could also see the distinction between minor and major being something where structural proposals were involved. So like if you're doing a zip line, you're doing structural supports where with ATVs you're not necessarily. So again, I think that's a policy decision, and I think this conversation will help.
Yeah, because I think, you know, with the minor major that Councilmember Wire is talking about, it's not talking about the terrain vehicles. I do not want people to have to go to the neighborhood board to present so they can use the ATV. Like, hi, I'm using an ATV on my land. Is that good with you guys? I have a ranch, I have a farm. Hi, hello, I'm using this. Like, we can't be doing that. A conditional major, you have to actually hire a lawyer. You have to go through a whole process. So I think this one, to me, is a no-brainer. If you write that they're using it for recreational entertainment purposes, that's not allowed. You're not supposed to be doing that. So then if it is for you to operate your land, then it shouldn't have to go through a laborious process of a conditional major.
Oh, yes, about that, I totally agree. If you're using an ATV as part of another principal permitted use, then you wouldn't be considered agritourism. You would start to be considered agritourism when you had ATVs that visitors were coming to ride around your property as part of their tourism of your property. So even if you, as your, you know, in part of your agricultural activities had several ATVs that your farm workers were using, that again would be under the umbrella of the principal permitted use. And that wouldn't be considered agritourism.
But also the point was brought up that many of the farms and ranches already have the conditional minor to have that use of it. So we're telling everyone that already got the conditional minor permit that now we're changing it. Now you got to get a conditional major to do the same thing you were just doing. I hear what you're saying, but then this whole process prior to this has been the conditional minor.
Yes. So anybody who holds a conditional use permit minor today, if they can continue operating as they are. If they were proposing a significant expansion of the use, and the use was previously a cup minor, and we, in reviewing their proposed expansion, find that whatever they're proposing to do qualifies as this conditional use permit major, then we would require them to go through that process. But it wouldn't take away what they had already. That would be in evaluating the expanded use.
Well, that's not clear in what's written here, but I hear you and I agree with what you're verbally saying. So yes, agreed. Thank you.
Thank you, Councilmember Wire.
Yeah, no, thank you. And I'm open to feedback too on, because I think, okay, if we just talk factually, like say you do horseback riding, you have an ATV that accompanies, maybe you have passengers or like customers that are on the horses and then on the ATVs, or even like you have a trail that goes through the mountains, right? I don't know. Very different than having like a big mud pit on ag land where you're just racing, or like they used to do in a point even, but say on ag land, right? And messing up the dunes and the shoreline. I don't know if there's a distinction in that in terms of wording or how to like signal where we obviously don't want to interfere or make it harder for folks that are doing what's right, but then we want to avoid folks from doing what's wrong, if that makes sense.
That does make sense, and I think that a mud pit for ATVs to wreck ag land would not be something that we would find met the goals and criteria for issuing a conditional use permit. So we would try, if we thought that that's what somebody was going to do, even if they didn't say it out loud, if we thought that was something that they might do, we might impose a condition of approval stating that the ATV tracks or areas would have to be clearly delineated and show that it wasn't going to impede on the agricultural land.
Okay, that's helpful. Thank you.
Okay, members, we're going to move on to beekeeping. With regard to beekeeping use, the beekeeping use as previously discussed, I'm recommending amendments to delete beekeeping as an accessory use under the accessory agricultural subcategory and include beekeeping as a principal agricultural activity in the outdoor animal raising use under the livestock and poultry keeping subcategory. Accessory beekeeping will not be regulated as a separate entry in the use table, and related beekeeping accessory use standards are being deleted. Beekeeping can take place as an accessory use or home occupation in other zoning districts, including zoning districts where people reside. Accessory backyard beekeeping involves small-scale beekeeping for personal use on the same zoning lot on which the beekeeper's dwelling unit is located will be subject to the animal nuisance relating to the keeping of honeybees in ROH 12-2.5B. Accessory commercial beekeeping as a home occupation will be subject to the home occupation standards in ROH 21-5.50-3B. The definition of the outdoor animal raising use now includes beekeeping as a principal agricultural activity in the P2, Ag 2, Ag and country zoning districts and is not subject to any standards. This approach to beekeeping maintains the current status quo in the existing land use ordinance where beekeeping as a principal use falls under the minor livestock production use and is not subject to any standards, and beekeeping as an accessory use is not regulated as a separate entry in the use table. I would like to propose a verbal amendment to the definition of beekeeping to amend the second sentence to read as follows. The term does not include accessory commercial beekeeping in zoning districts where home occupations are permitted, which must comply with the standards for home occupations. DPP, do you agree with this approach to delete beekeeping as a separate accessory use entry in the use table and include beekeeping as a principal agricultural activity in the outdoor animal raising use?
Good afternoon, Chair and committee members. Alex Beatty with DPP, relieving Elizabeth Krieger. Yes, we agree with this approach.
Can you please comment on one of the other proposals that would include beekeeping as a separate principal use under the livestock and poultry keeping subcategory that would be permitted in all zoning districts?
Yes, I think in the ag districts, the practical impact is the same as the other suggested amendment. Where it differs is what would be allowed as a principal permitted use in the residential districts, and I think that the approach being proposed by your office is appropriate.
Would my amendments to the beekeeping provisions maintain the current status quo in the existing land use ordinance with regard to beekeeping, insofar as beekeeping as a principal use falls under the minor livestock production use and is not subject to any standards, and beekeeping as an accessory use is not regulated as a separate accessory use entry in the use table?
Yes.
Members, do you have any questions for DPP on the beekeeping use? Moving on, with regard to the biofuel processing facility use, I'm recommending amendments to delete the biofuel processing facility use and include it under the agricultural energy facility use. It also deletes the standards and definitions since the biofuel processing facility use will be included under the agricultural energy facility use. The bioprocessing facility use is being retained, but is no longer permitted in the P2 zoning district because this type of intensive use is not appropriate for the preservation zoning district. And it adds a standard under the biofuel processing facility use that tracks the language in the state statute that in the agricultural zoning districts, agricultural land and uses in the vicinity of the biofuel processing facility must not be adversely impacted. Does the DPP agree with this approach to include the biofuel processing facility use under the agricultural energy facility use and to distinguish it from the biofuel processing facility use?
Yes, as discussed earlier, we think that this clarifies the zoning code and will make it easier to distinguish the difference between these accessory ag uses and the industrial type uses.
Members, do you have any questions for DPP about the biofuel processing facility use? You sure? Okay. Moving on to farm dwelling use, I'm recommending amendments to delete the standard that 51% of the activity on the zoning lot needs to be agriculture activity because it may be excessive for small farm operations. Clarifies that a storage shed that is not used in connection with agriculture activities will be included in the 5,000 square foot maximum area for the farm dwelling. Many farmers and ranchers use storage sheds as a part of their agricultural activities, not for personal use, so it shouldn't be counted toward the maximum farm dwelling area. It provides an exception to the maximum number of farm dwellings allowed if more farm dwellings are approved under an agricultural site development plan or agricultural cluster permit. The DPP had requested that the definition of farm dwelling be clarified to require that agricultural activity provide income to the household occupying the farm dwelling. I would like to propose a verbal amendment, therefore, to revise the definition of farm dwelling to read as follows. A dwelling unit that is accessory to a principal agricultural use on the same zoning lot other than open space or forestry where on-site agricultural activity provides income to the household occupying the farm dwelling. For DPP, can you please comment on the verbal amendment to revise the definition of farm dwelling? Does this satisfy your concerns?
Yes, it does. Thank you very much for including it in the verbal amendment. This basically brings us into line more closely with the state regulations for farm dwellings.
I understand that the Department of Agriculture recommends retaining the 51% standard for farm dwellings. Can you explain the rationale for the deletion of the 51% standard?
Yes, we don't believe that it scales particularly well as the size of the underlying zoning lot changes. So as another member of the community mentioned earlier, a particularly small lot might not be able to meet 51% and have a dwelling, but that doesn't mean that they can't have a very active agricultural use in a very small but intense way. In the other end of the spectrum, a 100-acre lot might have 49 acres of active ag, and that would not qualify them to live on the site. That's a lot of ag, and maybe some of that land is farmable, but is not immediately being farmed. So we would just rather not recognize the 51% as what gets you a dwelling. It's the participation in ag that allows you to have the accessory dwelling.
Since we do have the Department of Agriculture here, I wanted to give you an opportunity on this issue. Did you want to opine? And if not, you do want to opine, okay.
Thank you. Earl Yamamoto, Department of Agriculture. With respect to the 51%, actually 51% is the only tangible measure in Bill 64 with respect to many of the amendments that are going on. And I would think it would be especially important with respect to farm dwellings, which is the basis for the use of many of the lots of record here on this island in the agricultural district. Everyone wants that farm dwelling. So the farm dwelling, 51%, I think irrespective of the acreage size, is that really a burden upon the lot owner to comply with the 51% and have it dedicated or whatever.
You guys want to answer that? And then, you know, we're going to take both of your comments into consideration as we move forward.
Yes, we do believe that it would be detrimental to farmers under certain circumstances, like I said, particularly small lots, very large lots. And the end result of that is pushing the market for subdivision towards the minimum lot size. Larger lots would be more likely to subdivide into the minimum size that they could be in order to make it easier to get to that 51% and qualify them for a dwelling. Whereas a larger lot might be able to be retained, the long-term viability of a larger, potentially more efficient ag plan be retained if they could qualify at an earlier time when less than 51% of their lot was in active ag use.
So, if I may, so how would the absence of the 51% discourage further subdivisioning of the agricultural lands within the city county of Honolulu?
I'm not suggesting it would discourage, I'm saying requiring the 51% may encourage.
Okay, I'm going to come to closure on this issue, and no, I'm going to come to closure on this issue.
This is one of the, I think.
Are you going to direct it to who?
DPP.
Okay, thank you.
I would say this is probably the most controversial part of the entire ag section, at least in our district.
Sure.
Yeah. I want to make sure I'm understanding too. So am I hearing, like, for example, say you have 20 acres and you're farming 5 acres, which is still a decent amount given the agricultural climate we're in now, like if you're doing 5 acres of farming, right? You're saying that 51% you wouldn't be qualified to have your farm dwelling, is that what I'm hearing?
Yes, with the 51% in the bill, that's suggested to be removed, but in the bill now, yes. You would not be able to have a dwelling if you were only farming 5 acres of a 20-acre zoning lot.
Okay. I appreciate that. I'm open to suggestions, not at this moment, I understand, but I think that many in the community are concerned with, for lack of a better word, we'll just call gentlemen's farms, and how do we prevent the mass transition of agricultural land to these borderline luxury, they're 5,000 square feet, properties that aren't fully ag.
To be clear, we absolutely share that concern and are really trying to address it in a way that is practical and doesn't create any difficulties in order to start a farm and in order to start doing ag uses on ag land. So we are struggling with that same issue, and for anybody who saw the below the fold but still front page of today's paper, there was a Supreme Court case that came out yesterday that was sort of related to this. Interpretation of the definition of farm dwelling at the state law. We're still sort of sussing through exactly where that puts us, but the short of it, as I understand, was the plaintiff was saying that short-term rentals could be taking place in a farm dwelling because the farm dwelling was accessory to ag, and the Supreme Court sided with the county saying short-term rentals are not permitted on state ag land. So we think that that strengthens the position to have this definition allow us to enforce on potential gentleman farm situations. And I also just want to point out that this is a mostly helpful tool for us at permitting phase. We see building permit plans for new farm dwellings, and we can ask for an ag plan to say, show us where you're farming, and it needs to be sufficient to make the dwelling an accessory. It's easy and maybe convenient in the code to say 51% of your land needs to be an active ag in order to make it an accessory, but that's doesn't reflect other types of agricultural uses that may be more dense or intense, like mushroom farming or greenhouses, and it also doesn't reflect the reality of the huge variety of sizes of land that's in the ag district.
Mahalo. Mahalo, Chair.
Okay, thank you. If members, I'm going to be moving on. So with regard to farm stand use, I'm recommending amendments to clarify that one one farm stand for the growers and producers of agricultural products is permitted per zoning lot. If more than one farm stand is located on the same zoning lot, it will be considered an agricultural farmer's market that would require a minor conditional use permit to address potential impacts. Upon reflection, I will also be recommending the acceptance of Councilmember Tupola's proposal, as well as other stakeholders, so that for the farm stand standards in ROH 21-5.404 F2, it deletes the requirement that no electricity, sewer, water, or other utility services are allowed in conjunction with a farm stand. This appears in line item number 12 in Councilmember Tupola's council communication 2241, 2024. Councilmember Tupola, would you like to explain your amendment?
Sure. Thank you for incorporating it, and thank you for your consideration. Specifically, when we met with people who do farm stands, I mean, we definitely want people to wash their fruits. We need the water. We're not trying to like have a full-on store over there, but we also need light so that they can see. And definitely, if there's water, we want the water to go into the appropriate runoff, which would mean maybe some sewers. So we did think that it was not necessary to prohibit all of those things and still have a very DOH compliant farm stand. So thank you for doing that. I think that it's going to be good for the farmers.
Okay, thank you. For DPP, one of the standards limits the enclosed floor area for a farm stand to 500 square feet. There was the question of whether this conflicts with the 1,000 square foot limitation under HRS 46-88. My understanding is that the state statute 1,000 square foot limit is for an exemption from obtaining a building permit, and the city's 500 square foot limit is a land use standard. So these are two different requirements and do not conflict. What is the DPP's understanding of this?
We share that understanding that there is no conflict.
Thank you. As previously stated, I'm accepting Councilmember Tupola's proposal to delete the sentence that would not allow farm stands to have access to electricity, running water, sewer, and other utility services. What is the DPP's position?
I think we understand Councilmember Tupola's position and believe that it can assist with maybe more effective use of the farm stand if there's access to water and those kinds of things that were previously prohibited. The concern from our end was more about limiting these uses really to very minor accessories, pull off the side of the road, grab and go sort of situations, and less into there's a potential for it to be a string of attractions. I think that was the concern.
I understand, and I would like to think that there could be some self-regulation among the farm stands, as well as, you know, all of the, you know, the Hawaii Farm Bureau, council members. So I think those, if we see that, we'll deal with it as the time arises, okay?
Only if you promise.
I, Esther Puakela Kia Aina, promise to do my best to make sure that there's no abuse of authority under this provision. With regard to the farm worker housing use, I am recommending amendments to delete the requirement that the farm worker housing occupy the lesser of 5% of the total agricultural land area or 50 acres, and instead limit the farm worker housing to a contiguous total land area of 50 acres. It also deletes yard and height setback provisions because yard and height setback requirements are already governed by the underlying zoning district. For DPP, can you explain why limiting the farm working housing to a contiguous total land area of 50 acres is sufficient, and why limiting the farm worker housing to 5% of the total agricultural land area is not needed?
Sure. In the ag districts, the non-ag structures, which would include these facilities, is already limited to 10%. So there is already a limit. Furthermore, 5% may be a little too small for some of these ag activities that may require very intense labor for a short amount of time. That's really what this is intended to address, is the sort of semi-transient labor needs of these uses that have quick bursts of intense needs of human labor to provide housing for that.
Thank you. Members, do you have any questions for the farm working housing use? If not, we're moving on. With regard to other, I will also be recommending the acceptance of Councilmember Wyer's proposal to add dogs to the definition of livestock. This appears in line item number 8 in Councilmember Wyer's Council Communications 240, 2024, as modified in my response communication to specify herding dogs to differentiate. Councilmember Wyer, would you like to explain?
No, I think that satisfies. Appreciate Chair's indulgence.
And because if and thank you for your patience, members. I do see a light at the end of the tunnel, not only for Bill 64, but also for this hearing. And I think we're about 15 minutes away, if all goes well. So before I talk about setbacks, which was raised by the Department of Agriculture, as well as some of the other testifiers, I wanted to first ask to the committee members if anyone here had any other questions or discussion on any other questions before I wanted to ask a question on setbacks. You have any questions?
Well, I did just want to, yeah, if I may,
Yes.
briefly, because I know earlier during testimony the question came up about the limit on the Ag 1 zoning, right? The 1 for every 5 acres for farm dwelling, and then the Ag 2, 1 for every 2. Looks like, so that is getting stricken, it appears. I'll ask DPP. And so what would be the standard then for the number of dwellings on Ag lots?
It remains the same. So Ag 1, it's 1 per 5 acre. Ag 2, 1 per 2 acre. The question that was raised earlier, though, they also brought up the point of, well, what happens if you have a 100-acre lot?
Yeah.
Does that mean you could have 20 dwellings? And the way that we handle that, if I may, is from 3 to 6 farm dwellings, we require what's called a Ag site development plan. It's sort of a pseudo subdivision. You don't go through the subdivision process, but you show that you could. So you provide access, all the utilities that might be necessary, and you provide those maps to us, and we review it. So that's if you want 3 or more. So if you're entitled to 20 and you wanted to have 3, you would need to provide this Ag site development plan. Beyond that, there's an Ag cluster. Ag cluster is intended to clump all of the homes and services together in an area that may be inappropriate for farming to preserve more of the farm land for Ag uses. So under that situation, you could go up to the 20 that might be otherwise allowed.
Okay. Okay, so last question, and sorry if this gets district specific. So I'm assuming you're familiar with some of these parcels that we have that were sold off. Maybe there's like a group of tenants in common on a couple hundred acres or however much, and there wasn't a subdivision process, there wasn't X, Y, and Z. So the cluster application, you're saying that's a process where you can put in, do a plan, put houses in a particular area, and then the farming still, you know, the Ag is still doable on the rest of the lot?
Yes, so the prerequisite is that the dwellings have to be farm dwellings. So the people living there have to be doing some Ag use on the site somewhere. There's kind of 2 ways that they have been submitted before. One is each dwelling has its own related Ag CPR for area that's dedicated to them. And then in other situations, it's more collective, sort of along the lines of what farm worker housing would be, where a group of people are farming together and maybe share responsibilities, but don't have their own connected parcel that's just theirs for farming.
Okay, because then otherwise, if they wanted to CPR and do individual lots with houses on it, they'd have to do the subdivision process? Or no?
So the cluster, we review for certain criteria, and one of them is how well are you trying to preserve the land? So if somebody wanted to just do a subdivision looking cluster where everything was really spread out and there wasn't an efficient use of the land, we would deny it. We have denied applications like that in the past. The appropriate thing for them to do is a subdivision. It would be for them to go through the full subdivision application.
Which requires infrastructure and, okay, because and we'll talk offline maybe, but the problem we have is we have a bunch of community members on a large lot doing farming largely. I think the infrastructure, water, all that, there's issues, right, that seems like would make the subdivision process challenging. And so I think we're just kind of stuck, if that makes sense.
And we'd be happy to talk to you about that.
Okay, mahalo. Thank you, Chair.
Chair.
Councilor Chipola.
Thank you so much. You know, I thank you for saying there might be a light at the end of this tunnel. I want there to be one too. I have to ask these questions though. I met with hundreds of people and I need their voices to be heard. So we were specifically in regards to setbacks talking about the animal raising major and minor, which was part of the amendments that I proposed. And my note from Chair was that it could be revisited on October 22nd, which may be the case, but the reason why we did the animal raising major and minor was because major animal raising operations require a setback that might be more significant than minor animal raising operations. So we talked about that because this is all of Waianae, right? Every operation you have where you're raising animals doesn't require huge setbacks, depending on what animal you're talking about. So it's not just like every single animal needs to stay like 300 feet away or 1,000. So when I wrote this in my amendments, I specifically talked about feedlots, about grazing, other things that, you know, may not need the same thing as what a minor is. So if we can kind of look through this, because I do believe that Liz was on board with this idea of us trying to separate it out so we could talk about specific setbacks for different operations. Is that correct, Liz?
Yes, I think that based on the community input, the discussion about confined versus non-confined became very confusing about exactly how many animals would be confined versus not, whereas major and minor allows that distinction to not be so much about how many animals are, say, within a certain confined area, but rather it pegs it on how much dust, noise, smell, odors would be produced by that.
Yeah, so just for clarification, Chair, I crossed out the word confined and just made it animal raising major, and then animal raising minor was already there. But it was specifically because the setbacks were due to smell, noise, dust, of which some operations don't have as much of that, and therefore the setbacks shouldn't be the same as for larger operations. So that's my first question. Secondly, in regards to animal care, so animal care with this couple that just came up about whether or not you're indoors or outdoors, I worked with DPP on this one, and it's a real simple fix, and I'm hoping, you know, we can actually just adopt this, but we put in that in the apartment mixed-use business, so I'm on my recommendation line 3, number 2, in the apartment mixed-use business mixed-use, IMX1 zoning, major animal care must be soundproof and air-conditioned. That means that if you're in those areas, then you are required to do the things. But if you're not, if you're in agriculture, or if you're in country lots or whatever, then basically the rest of this pertains to you. So just putting it out there, that would actually resolve their concern just like that, is that when you're talking about those districts of IMX1 business mixed use, they have to be indoors, they have to be soundproof. But if you're not in a business district and you're out in the country, you don't need to have aircon out there. You don't have to soundproof it because you're out in the open. So Liz, what is your thought about that as far as like parsing that out?
Yes, I think that we had a really good discussion about animal care major and minor, and specifically how animal care major is allowed in the agricultural, the general agricultural Ag 2 district, and that would satisfy some of those concerns and track with what's currently allowed.
Thank you. Last question, agriculture equipment repair service. So the note I got and why my amendment wasn't accepted said, agriculture equipment service is defined as selling and repairing machinery such as in agricultural production and tractors, et cetera. So it is broader than only the repair of agricultural equipment. What I'm trying to say is the discussion we had was that specifically in number 1 and 2, that it was pertaining to repair services. So put the word repair, yes or no, Liz?
Technically, I think that it's the same either way, and I think that for your constituents, the word repair in there made it much clearer. So the DPP doesn't oppose the idea of adding the term repair to the title.
Okay, thank you. So again, I feel like only in Waianae do we do these things. So it was just not clear for people in my district, and it's a small amendment, but if we can incorporate it, great. So those are my questions, Chair. Thank you, Liz.
Thank you. A lot has been said on setbacks, and so for the staff who are helping me, I'm going to be proposing a meeting with the Department of Agriculture and DPP to further discuss all that we've digested today. So I just wanted to let you guys know that. I am actually going to move forward with my recommendations. The chair recommends that the CD1 version approved at the August 22nd, 2024 Planning and the Economy Committee meeting identified as OCS 2024-0830 be further amended to first, incorporate all of the amendments listed in my Council Communication 243-2024, and in addition, incorporate my verbal amendment to amend line item 10 regarding agricultural energy facility standards in ROH 21-5.40 for A1 to read as follows. No more than 10% of the portion of the zoning lot or lots used for crop production or livestock and poultry keeping may be used for the agricultural energy facility consistent with the regulation of permissible uses within agricultural districts pursuant to HRS 205-4.5A17. Add my verbal amendment to revise the definition of farm dwelling to read as follows. A dwelling unit that is accessory to a principal agricultural use on the same zoning lot other than open space or forestry where on-site agricultural activity provides income to the household occupying the farm dwelling. Add my verbal amendment to revise the definition of beekeeping to amend the second sentence to read as follows. The term does not include accessory commercial beekeeping in zoning districts where home occupations are permitted, which must comply with the standards for home occupations. Second, incorporate the following amendments in Councilmember Wyer's Council Communication 240-2024, line item number 2, a portion of line item number 5 and line item number 7, which relate to separating the agritourism use in minor and major uses with a minor conditional use permit required for the minor agritourism use and a major conditional permit required for the major agritourism use. Line item number 8, to add herding dogs to the definition of livestock. Third, incorporate the following amendments in Councilmember Tupola's Council Communication 241-2024, line item number 12 relating to farm stand standards in ROH 21-5.40-4F2 to delete the sentence providing that no electricity, sewer, water, or other utility services are allowed in conjunction with the farm stand. Any further discussion, any objections, any reservations? Hearing none, the bill has been amended to a CD1. The chair then recommends that Bill 64, 2023, FD1, CD1, be postponed to the next committee meeting on October 24th, 2024. Any objections? Actually, that should be October 22nd. I'm sorry. That would be October 22nd, 2024. Any objections, any reservations? Hearing none, so ordered. So today we've covered the accessory agricultural subcategory and have now completed the agricultural use category. I just wanted to thank the agricultural use took a lot of work, and it's imperfect, and we are still gonna be open to non-substantive changes. But I did want to thank all of these individuals and stakeholders for their kokua on this. Lori Hiraoka with the Council Support Services, Brianne Uhiva of my office, Office of Council Services, the Department of Planning and Permitting, and the Department of Agriculture, as well as the Hawaii Farm Bureau, Ulupono Initiative, and all of the various stakeholders, and Councilmember Tupola and Wire for your community engagement relating to this issue. At our next committee meeting on October 22nd, I plan to address the miscellaneous category, which covers the following: historic structure reuse and transfer of development. At the October meeting, I will also entertain cleanup amendments to all use categories that we have completed thus far: agricultural uses, residential uses, public, civic, and institutional uses, commercial uses, and industrial uses. I want to emphasize that the cleanup amendments are not meant to be major substantive amendments, as we have already carefully considered the uses in each of these use categories. I'm going to read this sentence again. I want to emphasize that the cleanup amendments are not meant to be major substantive amendments, as we have already carefully considered the uses in each of these use categories. My hope is to report out the CD1 version of the bill from the October committee meeting for second reading and a public hearing at the full council meeting on November 7th, 2024. We have worked long and hard on this bill, and I feel we have made excellent progress and improvements. When the bill goes back or comes back to the Planning and the Economy Committee after passing second reading and the holding of a public hearing, I would like to consider the bill at the committee meeting on November 21st and report the bill out for third and final reading in the full council meeting on December 11th, 2024. Before I come to closure on this hearing, I made a commitment for those testifiers on agenda item number 3 that I will allow them to testify if they are here. And first, clerks, I want to find out if Leslie Among is online.
Chair, testifier is not logged on.
Are there any testifiers regarding agenda item number 3, which was our informational briefing, which was the status of the City and County of Honolulu's enforcement for violations on a agricultural parcel in KUNIA? Please proceed.
Aloha, Angela Melody Young, testifying on behalf of CARE. So agritourism is regulated under civil liability, agriculture, and land use zoning laws. Agricultural businesses, if it's safe and does not compromise on environmental standards, will create—
Angela, I'm sorry. You are going to focus on what was on the agenda.
Yes, the status of
We don't need a tutorial.
Okay.
You are going to stick to what is your position with regard to the city's enforcement of the violations on this parcel?
I think the city should relax the rules for the enforcement of the violation. Let the agricultural tourism business appeal the offense, because we don't want families and businesses to be limited in their diverse creative skill set, right, in small business operations. So you want to encourage production of local farmers, craft makers, fashion designers, showcasing what it means to be from Hawaii, to set a standard for agriculture, food business, coffee farms, right? And what it means to be from the Aloha State. So it's time that not only the law is legislated to uplift these businesses, because these agriculture tourism businesses have very restrictive rules. And for example, a coffee farm from Hilo cannot operate coffee tours at night.
Thank you for your testimony.
So, thanks. Yeah.
I have an announcement. Councilmember Tupola, and I'm sorry for the stakeholders who had left already, but hopefully they'll know about our introduction of a resolution 24-243 yesterday, which would reconvene the Honolulu City Council's Agricultural Development Task Force to foster the growth and enhancement of agricultural activities on Oahu. I plan to include this resolution as an informational briefing item on the agenda for next month's hearing on October 22nd, so we can start the conversation on this important task force. I'm actually looking forward to the members' mana'o on the provisions of this, because we are actually reconvening the task force, and so I'm open for you to look at the provisions under this resolution. Managing Director, before I close, did you want to say anything?
Committee Chair Kia Aina and council members, thank you for that opportunity. I did come in because I wanted to correct the record. When I testified earlier on our enforcement, I made some reference to not being happy with things that are happening at the neighborhood board. And I wanted to be more specific and clear about that. The neighborhood board, through the chair, Danielle Bass, has been very good about not pandering to one community member who has asked them to agendize and have a conversation about what's going on with the Malco Warriors luau. And so the frustration that I've had is that there is a continued request to the neighborhood board to agendize this and to have conversations that I think should be had before the city council. So that was what my comment meant, but I in no way intended to criticize the actions of the neighborhood board chair or the neighborhood board, because they've been extremely professional and proper in the way they've handled that agenda item. So I just wanted to clarify that, and thank you for allowing me to do that.
Thank you for that clarification. Mahalo, everyone, for being here today. There being no further business, this meeting is adjourned.